Good afternoon. That's the House Judiciary Committee on the 14th of February, 2024 at 1 o'clock. We have several bills to hear, including this first one, House Bill 592, for which we're happy to welcome the Chief Judge, Matthew Fader, and also Judge Cotton from Prince George's, from the circuit, from the Seventh Circuit, right? All right. Chief Judge, okay. So many Chief Judges. So if you'd like to go ahead, who would like to go ahead first? Whoever would like to go ahead.
I will start and be brief, Mr. Chair, members of the committee. Thank you very much for hearing us today. And just to be clear, I'm very pleased to be joined today by Judge Danica Cotton, who is the administrative judge in charge of the Circuit Court for Prince George's County. And just as a little aside, the chief judge is the judge who has been the longest serving judge on that court. The administrative judge has the administrative responsibilities for both the circuit and the county. And we are here because the judiciary every year does a needs analysis for new judgeships according to a methodology that has its origins in the National Center for State Courts. We've been using it since 1979. It's a very robust methodology that is intended to identify workload in the courts and identify the need for new judges. This year, application of that methodology identified a need for 6 new judgeships in the state for a variety of reasons involving the courts and the workload and predictions and space in the courthouses. Frankly, we are here looking for 1 new judgeship, and that is in the Circuit Court of Prince George's County, which does have a demonstrated need for that. And with respect to that, I will turn it over to Judge Cotton.
Good afternoon. My name is Judge Danica Varner Cotton. As he said, I'm the administrative judge for Prince George's County and for the 7th Judicial Circuit. I've been appointed back in January of 2023, so I just had my anniversary. And I've been an associate judge for 18 years. I want to thank you in advance for the opportunity to testify on this bill. Currently, we have 24 judges in Prince George's County, and our request today is for 1 additional judge. Prince George's County has been deemed in critical need of additional judicial sources. I want to tell you a little bit about the percentages for Prince George's County. In the past year, we've had a 25% surge in filing of criminal cases, 34% surge in the filing of family cases, 34% increase in requests for search warrants from law enforcement officers, 35% increase in guardianship filings. So our need is critical. Our budget team has met with the county council and the county exec, and we have approval for additional support. Our courthouse has adequate space available to support a new judge and their staff without the need of additional monies to enhance our physical structure. Our county continues to grow, and case filings, as I described, has increased daily. I'm here to show support for the addition of additional associate judge, which is supported by the fiscal year study. Additional judge will allow us, Prince George's County, our court, to serve more efficiently and timely services to all the citizens that come to Prince George's County Courthouse. And our courthouse in Prince George's County has the highest number of visitors every day of all county buildings in Prince George's County. So I want to thank you in advance for this request, for paying attention to this request, for helping us serve our citizens in Prince George's County. And I'm happy to answer any questions that you have.
Are there questions for the panel? Delegate Boucher.
Thank you, Chairman. You're adding a judge, but you don't need another courtroom. You don't need to expand the court facility.
No, we are very blessed in that we have another space for a judge, their law clerk, for their administrative assistant, and we have courtrooms available as well. We've expanded in the last 10 years.
Thank you very much.
You're welcome.
Anyone else? Seeing none. Thank you both very much, Chief Judge.
May I just make one clarifying remark, just to make sure I'm not misleading the committee? My comments about administrative and chief judge were with respect to the circuit courts specifically. At the district court and the appellate court level, the chief does have the administrative responsibility. Just wanted to make sure, since I said that too broadly earlier.
I'm not old enough to be the chief judge yet. That's
the real takeaway.
Noted for the record. Thank you very much.
Thank you.
Thank you very much. That concludes the testimony on House Bill 592. We're going to go now to the Vice Chair's bill, House Bill 698. And there are witnesses. Well, which I think we might be able just to get them in one, but we'll find out. Allison Taylor, Kai Shea, Terry Ziegler, Dean Townsend. No, okay, we won't quite get everybody in. Well, maybe we will. Let's find out.
So if Virginia's signed up to testify, she's here. I don't know if she stepped away, but
How about Peter Tallarico, Helen Hash, Sigrid Haynes? Up there is, I'm wondering whether there they come.
yeah, they might have been looking at the monitor.
Dean Townsend, okay, the whole group just showed up. All right, let's try this again. I'm gonna swing back to where I was initially. We have Delegate Bartlett, Allison Taylor, Kai Shea, Terry Ziegler, Pegeen Townsend. All right, we're gonna start with that, and then we'll have another panel after that, and we'll go with the vice chair. Go ahead.
Okay, thank you, Mr. Chair. Hello and happy Valentine's Day, members of the House Judiciary Committee. For the record, I am Delegate Sandy Bartlett from Anne Arundel County, District 32. House Bill 698, as drafted, does two things. It requires a court to rule on petitions to appoint a guardian of the person for the purpose of making decisions relating to discharge from a hospital within 10 days. And it allows hearings to appoint a guardian of the person of a disabled person to be held virtually. So we're going to talk about, and some members of my panel will talk about the impetus behind the bill and how we came to this bill because of a need for some reduction, and we've all been hearing it, of emergency room wait times. Some people are staying in the emergency room for 30 days or more, and they're ready to leave, but there's no place for them to go, or they need a guardianship appointed. So there was a work group that was held, and the work group concluded there are multiple factors contributing to the problem that I just mentioned, including insufficient care options outside a hospital, and that there are inefficiencies inside the hospitals, and the ability for the hospital to discharge individuals, as I spoke about just a minute ago. So regarding timely discharge of disabled individuals, the work group heard over and over there are significant delays in the appointment of a guardian, and there are wide variations between jurisdictions on the time it takes for the court to appoint a guardian. Unfortunately, there are consequences associated with those delays. I spoke of 30 days or more inside the hospital. More importantly, the patient is not in the right setting to meet their needs. If you don't know, elderly individuals, long-term care in a hospital is actually very detrimental. Lastly, allowing for guardianship hearings to be held virtually will make the process more efficiently. And so I have let you know, I've met with stakeholders. You'll see a lot of unfavorable testimony, and we discussed the bill. We determined that we do agree on virtual hearings, and we would change the shall to a may, as well as have appropriate accommodations, just as someone would have in the court system. The common point of the contention, as you will hear, is about the expedited permanent loss of rights for a disabled person, and we will kindly entertain any amendments that the committee wishes to present. Thank you very much, and we will continue, Mr. Chair, if that's okay with you.
Thank you, Mr. Chairman, members of the committee. Pegeen Townsend on behalf of the Maryland Hospital Association. This is not a new issue for us. This has been of concern to us for over a decade, the time it takes for guardians to be appointed. And we've been increasingly frustrated that we cannot find an accommodation to get the system to work better for us, because as sponsor said, when patients are sitting in a bed upstairs for months after their need for acute care services was fulfilled, they're sitting there for months. That means people in the emergency room can't get upstairs. And when they're there for months, that means a whole bunch of patients couldn't have gone to that bed. So it's multifaceted, and that's a community concern. It takes away beds for those that do need it. We're hoping that we could sort of elevate our need for this issue to be resolved by this bill. And we hope we can garner some solutions and develop some solutions to address our concerns, because this is with the emergency department wait times, this has actually really elevated this issue for us. And that work group that she talked about had this as one of their highest priorities. There's not a lot of legislation you could think of to help us with emergency department wait times. It's internal, it's outside of the hospital, it's at discharge. But this is one small area that would really make a big difference to us if we could get this resolved.
Good afternoon, Mr. Chair and members of the committee. My name is Allison Taylor. I'm here on behalf of Kaiser Permanente. We're not in front of you very often, but Kaiser is a comprehensive health system that provides exclusive care for members who have Kaiser insurance. And we have dedicated space in hospitals where Kaiser members are seen, and this is 100% an issue for Kaiser, the same as it is for our hospital partners. So speaking in my role as a health insurance representative too, I will speak to the fact that, as you all can imagine, hospital care is extremely expensive. And if it's not needed, if someone can be treated in a different way, that's obviously better for the whole system. So this is an important issue, important piece of legislation, and we urge a favorable report.
Good afternoon, Chairman and members of the committee. Thank you very much. My name is Terry Ziegler. I am the Director of Social Work on behalf of the Johns Hopkins Hospital, and I appreciate the opportunity to speak with you today. As you may know or may not know, these individuals that present to our hospital are just like you and I. They are parents, they are daughters, they are siblings, they are friends, and they are neighbors. They come from all ages. They are not just the elderly. There are many young people that present in these situations. They come to us following strokes. They have dementia. They have been found down in their home. They may have been assaulted. They may have been pedestrian struck. But all of them present to us with severe cognitive impairment and behavioral challenges that only worsen over time. They have agitation. They are restless. They're paranoid and impulsive. They have fall risks, and they often require sitters and restraints to keep them safe. Some of these individuals may have family. They may be estranged from their family, and often many have no one. And even those that do have somebody, they are not in the position of taking care of these individuals. Their needs far exceed one individual's ability to take care of them. They are trying, we're all trying to find them an appropriate, safe environment to which they can transition to. However, they don't always have the resources to provide for their care after the hospital. They don't know what their funds are. And they certainly may not have access to those funds if they don't even know what the funds are. As you know, Johns Hopkins Hospital is a national and international provider for hospital care for very complex patients, and others depend on us. We have capacity constraints, and if we are not able to mitigate those, we are unable to accept the patients we need to take care of. We need to be able to effectively and efficiently move these patients through this guardianship process. And if we can do that, then we can take care of the patients that need to continue with their care at Johns Hopkins.
Thank you very
Thank you.
much. Please.
Good afternoon, everyone. My name is Kai Shea. I'm a practicing clinical social worker, but I'm also the executive director of care management at Johns Hopkins Bayview Medical Center, and I've been practicing in East Baltimore for 25 years. And I thank you for the opportunity to testify today. The acute care hospital is one of the most highly restrictive institutional settings that you can think of, and prolonged stays for patients there have adverse effects on them. In the hospital, we care for the sickest of the sick, and despite meticulous infection control practices, patients awaiting a hearing can still have exposure to pathogens which can make them very ill. Patients are expected to stay in their rooms for the majority of the day because of our infection control processes. There are no common places to gather, so essentially, they suffer confinement to the same room for weeks and sometimes months, with the limited ability to go outside, to feel the sun on their face, or to breathe fresh air. Since many of our patients who are waiting are older adults, there are disruptions in the hospital with buzzers and bells and beeps, which put them at high risk for delirium, which causes an even higher risk of declining health and even death. Many of the patients awaiting guardianship have complex specialized needs, and we work very diligently to try and make plans to transition them to programs for traumatic brain injury, rehabilitation, assisted living, etc. All of this necessary care is postponed while the patient is waiting for that hearing, leaving them in a limbo and withholding access to these crucial services. Every day in healthcare, we try to provide the right care in the right place at the right time. The long waits that our patients experience to have their case heard in court have impacted the ability for us to do this, and it has put them at adverse risk for bad outcomes. These are some of the most vulnerable members of our community during these waits, which prevent they have no representation and no voice. Please help to resolve this problem by supporting this bill. And thank you again for the opportunity to testify today.
Are there questions for this panel? Delegate Kaufman.
Thank you, Madam Vice Chair. I have one question for the lady from Hopkins, if it's okay, Mr. Chair, and one question for Madam Vice Chair. First of all, Madam Vice Chair, I'll start with you. First of all, happy Valentine's Day. I hope that Scott spoils you later. My question though is, have you read the testimony of the DD Coalition, which includes the Developmental Disabilities Council, Disability Rights Maryland? They are People on the Go, the leading self-advocacy organization, because they came out and I'll just read you the last sentence. They say, "We are deeply concerned about the risks of that HB 698 creates for people with disabilities being placed under unnecessary plenary guardianships." They talk in their piece about how they think supported decision-making is better, and that there's a from the hospital to a guardianship pipeline. So I was just wondering if you had a chance to reach out to some of the disability groups, or if you wanted me to text you some of their contact information later. So what's your response to the opposition of the DD Coalition?
Well, as a board member of Bay Community Support Services for 4 to 5 years, I have deep respect for the intellectual developmental disabilities community. And I did actually meet with individuals to hear what their concerns are. And I found them I found their concerns to be with merit, because, you know, we don't want to, and I say this in my testimony, we don't want to permanently take away anyone's rights if it's not necessary. I agree that supportive or surrogate decision-making, in fact, I voted for that bill. I agree that that is a great tool. In the meantime, we still have the guardianship section in our estates and trusts law, and that is another tool. There is in the last sentence of my testimony, or last 2 sentences, there is a section that we are going to look at, and I'm going to have to bring all the stakeholders back together. Again, it may be virtual, but there is a section 13-204 of the Estates and Trusts where there is that it does allow for authorization for a specific means that doesn't require appointment of a guardianship. So it's temporary guardianship. So we're still having conversations. I think we're going to want to continue to have conversations, and the developmentally disabled group will definitely be a part of that of those conversations.
Having known you personally for a few years now, I know you deeply care about this community, and I really appreciate your work on this. And my question is for the Hopkins social worker, if I may. You referred, and I don't doubt I don't doubt the negative experiences, but you referred to patients in your testimony. in a very unflattering way, and cast a negative light on patients. And so I'm just wondering, could some of this misconduct in the hospital, for lack of a better word, be because in fact the staff is not very familiar with the disability community or how to interact with these people? Because I just wonder if that's a possibility, because we're not supposed to do this, but I will, and say that in my experience, because I've spent more time in the hospital than I care to admit, I tend to know a lot more about developmental disabilities than the people I encounter in the hospitals. So could it just be a lack of training also?
If I understand your question, is staff training important in taking care of patients in general, and particularly patients with complex care needs who may have cognitive impairments? Is that correct?
Because no, what I said, my question was this. My question was that could some of the misconduct that you described in your testimony be mitigated or lessened through more training for hospital staff on how to interact with this population?
Sure. So if you're referring to patients who have fall risks or are impulsive, might be restless, yes, sure. Training is incredibly important. And I can speak as a social worker. It's important for us to know, as social workers, the clinical expertise and skills to interact with patients and their families who are not safe, and to try to help educate others on safety precautions.
Thank you. Go ahead, Taylor.
Thank you, Mr. Chair. I've been in the home care, the long-term care space for almost 30 years, and I realized that this is a big issue. I was happy to hear Delegate Bartlett say that a part of this is temporary guardianship. There's a question in there. I've seen where there have been our seniors who are loopy, so to speak, not necessarily, on the Alzheimer's or the dementia spectrum, but are loopy because of medicines, right? And I guess my question for you is, do we have an advocate for this senior in your hospital systems that can say, look, when they came in here, they were in their right mind, but somehow this combination of medicines has caused them to appear that they are not capable of making these decisions. So just, you see where I'm going with this, right? So if you could answer that, that'd be great.
I can take this one, and thank you very much for your question. I think you're hitting the nail right on the head here. Most of the patients that we're talking about here have some sort of permanent incapacitation. There are many folks who come into the hospital who, for reasons of illness, medication interaction, or environment, become delirious. Delirium is a temporary condition, and we work very hard in the hospital to mitigate that by movement, night and day management. And there are many people on the nursing staff, the physician faculty, social work staff, the clinical staff, who work to mitigate the risk of an older adult particularly, but there are many other people who can suffer delirium to help our patients to get well. It is a medical condition, and to get back to their baseline of mentation. So the people that we're talking about, where we have a lot of trouble in care transitions, are not people with a temporary condition such as delirium, but rather a permanent condition such as a traumatic brain injury or a dementia or some other sort of neurological sudden injury, stroke, et cetera. I hope that answers your question.
Is that particularly spelled out in this bill?
No.
Or
And Delegate Taylor, let me just, I want to make sure I clarify something. The temporary authorization for discharge without appointment of guardianship is not a part of this bill currently. What I would like to do, and I wanted the committee to know that I do want to go back to the stakeholders that we met with and offer that amendment to see and to totally flush it out, to see if there's any benefit in a temporary, and I say not quite temporary, but the authorization for certain specific things as it's stated in 13-204. So let me not mislead. It is not a part of the bill currently, but that idea came late in the day, and we just haven't had a chance to flush it out yet.
Thank you, Mr. Chairman. Thank you all very much for coming and providing your important testimony. Sounds to me, so there's two parts to the, and it's always good to see you, Ms. Townsend. Welcome back. I didn't think we were going to see you this year. Okay, so there's two parts to the bill. Sounds to me, Madam Vice Chair, that the second part of the bill looks like, I guess that's for the virtual hearings to be the default is.
No, not the default. I'm sorry. I want to make clear. We're striking shall to may.
To May.
Yes.
To May, but
Yes.
it's gonna be the default that it will be May, and then that it'll be virtual, and then somebody can ask for it to be changed back to in person. Is that?
No, the default would be, it's actually up to the individual. That's why it's a may. So if the individual asks for in person, they could have in person. If they ask for virtual, they could have virtual.
Okay, and are you going to include in that that interested persons and the court can also chime in and make that decision to bring it back to a in person? Is that something that you would consider as an amendment? Because you don't have interested persons or the court, and they may decide that there's invested interest in.
Right.
So if, let's say the person who's who's under the question of the guardianship says, oh yeah, we'll do virtual, but then the court says, no, we really need to have this in person. Is that something that you would consider to be an okay?
Yes.
Okay.
Yes.
And then the other question is, if it's contested, you're still going to allow it to be virtual, even if it's contested?
Well, I think given what you just said, with having the court to be able to weigh in on virtual or not, I think that would take care of whether or not it's still in the best interest of all parties to be able to have a virtual hearing.
And the reason I say that is because the issue with virtual hearings in contested matters, it's difficult to determine if a person on the screen is getting coached. And it's also, if there are any notes, those notes are permitted to be provided to the opposing party or the opposing counsel, and they can't necessarily get it.
Right.
So,
and let me just make sure that everybody understands that virtual hearings for guardianship are, they became a thing just like everything else did during COVID, where they are being utilized now. This is just pretty much putting it available in this section, adding it to this to make it available if someone wants it, if someone needs it, as opposed to the court saying that it's going to be a virtual hearing.
one more thing.
Go ahead.
So this is the problem with having a sister who's a elder care attorney who handles destitute and disabled people who are in hospitals. So she briefed me for hours on this.
Sorry.
Okay.
I wish I had talked to her before.
Believe me, I think you're going to. Okay, so
Oh, no.
so the issue on the 10 calendar days. So in a typical
Oh, yeah.
guardianship for non-contested, it's a 5 to 8 week process in the initial petition so that they can determine if there's any interested parties or if there's any reason for it to be contested. That's just for the initial petition, 5 to 8 weeks. That already goes way past the 10 days. That's just to make sure. And then if it's contested, then there's an issue of discovery and making sure. And the whole point of it is that these are people who deserve to be treated with dignity and respect. And I understand. And by the way, your goal is laudable. And we should make sure we do whatever we can to make sure the hospitals have as much room as they can. And they're not there longer than they need to be for health reasons as well. I agree with what you're trying to accomplish. I'm just worried about the due process of these people, particularly people who may be suffering from dementia or other ailments that you were talking about. And unless they're represented by counsel, and even if they are, if we are expediting these things to a point where they're losing their due process and losing their ability to be treated correctly, we have to make sure. So it sounds like that first part, we're still under some significant. Okay.
I would just respond to that. If you think about it, they don't have any representation while they're sitting in the hospital. So their rights are being compromised, if you will, because they're sitting in a setting where they don't belong. It's not appropriate from a clinical perspective, and they're not being represented in a timely manner. So I think it cuts both ways.
If the guardianship or there's a determination that they are going to be required to leave in whatever form that you do it, and then the services that are required for them are not available, and their situation could be far worse. I'm not saying that there could be, there's also the cost to the hospital in terms of not being able to provide services to other people, and I understand that, but this person deserves to be treated with the dignity and respect that we can give.
I couldn't agree more. I could not agree more.
No.
Thank you.
Further questions? Seeing none, thank you all very much. I'm sorry, who's got it? Oh, I'm sorry, Delegate Tolles, I beg your pardon. Go ahead.
Okay, thank you. Thank you, Mr. Chair. We had an opportunity to meet, and so I appreciate that. I do agree with what both my colleagues, Delegate Taylor and Delegate Carter said. They brought up basically my points. Was I am concerned with, well, let me first back up and say that I noticed that I think it's worth taking a pause on this, because you have the Judiciary Committee, the AARP, and the Department of Aging unfavorable with this bill. So I think those are very important entities that play a role in our aging community. And so particularly with, AARP, and one of the things I agree with Delegate Carton on is that we do need to make it less restrictive. And I know when we spoke, we talked about that 10-day. And I was very concerned about that in terms of having that adequate time to have someone only have 10 days to get that guardianship. And so I do think we need to look at that time frame. I have very strong feelings about that. And just for the record, I don't know if you had an opportunity to look at AARP. They talked about adequately funding guardianship programs. I mean, I think ensuring that individuals have, whether it's through health insurance companies, making sure they have proper documentation. If you know that someone's disabled and could likely be put in the hospital, to have that done beforehand, but to cut those services. And I'm going to get to my question, which is, again, are you willing to amend this bill to deal with that 10-day time frame?
Absolutely.
Yeah.
Nothing's cast in stone.
Yeah.
But I would say putting this bill in got people coming out. And I think that's a dialogue that we've been missing for a while. And I hope we can work collaboratively to find a solution that works for everyone.
And yes, and again, what Delegate Taylor said in terms of the medication, are you going to, so you're saying that you will put something, yes or no, in here regarding that medication or something? I'm sorry, Delegate Bartlett, Madam Vice Chair, indicated some type of temporary language.
I like the idea. I'll say I like the idea. And I'm not saying this is definitely not a no. What that language is going to look like, I don't know at this time, but I do like the idea. And in fact, I was going to start my testimony with folks, this is what conversation looks like. And that's why you see so many unfavorables, because we're still in the process of conversation. Conversation is not complete yet. However, bill hearing was today. So we have to be here and we have to actually, present the bill. So that's what we're doing. But please know that we are still in conversation and ideas are still coming. And so there is a huge willingness to work towards doing what is right for the patient and also doing what we can do to reduce hospitalization time. So that's the position that we have on the bill.
Thank you. Just a final thing, have you all, do we have, you may be able to answer this, or Delegate Carter's sister, do we have a uniform adult guardianship and protective proceedings act in the state of Maryland? Because that's something AARP is suggesting that would be beneficial. Does that
Well,
exist?
if AARP is suggesting, I'm gonna go with a no, that we don't have it yet. But I will say that there are some uniform directives, language and forms of that sort that we do have available. And some hospitals will even have like a little card. And on that card, it will state who they want to make certain decisions and things of that sort. And literally, my mom's card was just worn because she kept it in her wallet and she only pulled it out when she needed it. And that was towards the very end when I was making decisions for her. So I'll just say that I'm not opposed to anything that is going to get folks out of hospitals because I do know, and I saw firsthand, that it can make a difference for someone if they're not in a confined area. We all know that, our lives are going to be what they are and our time is going to be what it is, but anything that we can do to make sure that folks are not languishing in a hospital is always a good thing. And we'll figure it out. We'll figure it out.
I'll just add, another frustration for us is every county is different. Some counties do this very well. And in fact, Baltimore City does it very well. And so, there may be some sharing of best practices amongst some of those folks would be helpful as well.
Just had to deal with this issue with my mother, so I had to make her decision. So I definitely think I'm concerned with hospitals trying to quickly get people out where I think that may be the best course of care for them, even if it is a way to try to reduce wait times or get folk out quicker. But I do think being in the hospital is beneficial.
One more quick thing I want to make sure I add is Medicare, I believe, has an appeal. There is a federal law that if an individual, especially an elderly individual, is being discharged too early, that they can file an appeal. I can't give you, I can follow up with you all on the actual law, but there is a law that states that if you are, if you feel like you're being discharged too early, you can make that appeal. Now, I'm saying that because I want you all to know that that exists. That wouldn't change with respect to the text of this particular bill with respect to any guardianship appointment, but I wanted you all to know that that does exist.
Thank you, Mr. Chair. My question will be relatively quick. I really want to understand the magnitude of the challenge, because we are talking about. I would suggest that most people that come to the hospital do have someone who is in responsibility for making healthcare decisions if they can't make their own. Is that a fair statement? And if that is a fair statement, how large of a problem is this? Just so that we have some perspective.
And some of the witnesses behind us will talk about the number of days people have, over the past year, how many days were overstays. So we have it in that context.
Oh, thank you.
Yeah, you're right. Most people come in with either they have capacity or they have somebody they can make decisions for. But in these cases, they end up staying so long that it backs everything else up. It's the time that they're staying.
And any magnitude?
These folks behind me.
Seeing no further questions for this panel, thank you all very much. We'll go to a second panel now. Peter Tallarico, Helen Hash, Sigrid Haynes, I think that's everybody who signed up in favor of the legislation. Whoever would like to go first, please.
I'd be happy to go first since I have the numbers that were just previously asked for. I'm Helen Hash. I am the Director for Care Management for University of Maryland Medical Center for the downtown campus. I have a couple of numbers to share with you. The first is 4,384 days, patient days spent in excess in the hospital. And that is over 69 patients involving our 13 system hospitals. More than 60% of those numbers are patient days incurred from our flagship hospital at University of Maryland downtown campus, our only tertiary and quaternary care hospital where patients across the state and the region are waiting to be transferred for treatment. I want to make it very clear that this is not about numbers or money, that this is about people on the inside of the hospital while a guardianship hearing date is pending for them. And these numbers are the actual dates from one step to another, the file date for the guardianship and the actual guardianship date. It does not take into account the days in advance where social workers are working very diligently to try to find family members or other surrogate decision makers who may be able to speak on behalf of the patient who is waiting. And it doesn't take into account after the guardian has been put into place, while that guardian makes very purposeful decisions for that patient so that they are put in the best next level of care, the lowest, most or least restrictive level of care for the remainder of their time that they need care from other patients, other hospitals.
Peter?
Go next. Mr. Chairman, members of the committee, thank you for addressing this important issue. My name is Peter Tellerico. I'm the Director of Risk Management and Patient Safety for Holy Cross Health. I'm a registered nurse and I've been working in risk management for over 20 years, dealing with guardianships. Guardianships are the least efficient way to assist the patient to an appropriate living or care setting following hospitalization. They're costly and time consuming. Hospitals do everything possible to avoid them, as you just heard. Starting at admission, patients and families or friends are advised to prepare for what patients might need after they leave the hospital. Sadly, many of the patients requiring guardianships have limited community support. For some, simply identifying who they are can be a challenge. Of necessity, care providers have become adept at searching for personal information. All leads are followed, checking cell phones for emergency contacts, searching healthcare records, including the CRISP Health Information Exchange, are now routine activities for healthcare providers. Sometimes the police are called in to fingerprint individuals to a comatose patient to establish an identity. In other cases, a private investigator has been employed to pursue leads, and he has even been sent door to door looking for contacts for patients. Homeless shelters, local embassies, they've all been queried. We make multiple international calls trying to find anyone that could speak for a patient. It is only when all of these options are exhausted, and this can sometimes take weeks, that guardianships are pursued. And once a guardian is named, as just has been mentioned, they still have to obtain access to the patient's finances before any placement decisions can be made. A 2-week hospitalization can easily turn into 2 months or longer. In the meanwhile, the patient languishes in the hospital room while individuals with acute care needs do not have access to that bed. Making hospital-initiated guardianships a priority for the courts would improve care for some of the most vulnerable patients and would help to alleviate the backlog of patients in Maryland's emergency rooms. Thank you.
Thank you, everyone, for attending this important hearing. My name is Sigrid Haynes. I'm a partner at Whiteford, Taylor & Preston. I've been doing guardianship law in Maryland for hospitals for more than 35 years. I have served as a guardian of person, a guardian of property. I have represented alleged disabled parties, and I have filed a number of guardianships. These are our most vulnerable hospital patients. I get frustrated when I hear that the disability rights people are opposing this, because I feel that these patients are not being well represented when they're sitting in hospitals without an advocate to look out for them. These are people who don't have family, don't have friends. They are people who really need support from, frankly, the guardianship system by having an attorney appointed to represent them and have a guardian to look out after their interests. It frustrates me that these cases sit in hospitals for months while we're waiting for the court system to process them. I just had a private guardianship case of a woman who was filed at the beginning of November. We had a hearing earlier this week, 3 months for a 5-minute consent hearing for her to have a guardian appointed so that she can be appropriately placed in a facility which can meet her needs. She's got dementia. She lived alone. She never had children. She never married. And this is going to be me in a few years. So I feel strongly about this. It's not right that a person like that stay in a hospital room without social support. The courts are not processing these cases as quickly as we think they should. Maybe 10 days is not the right number. We can certainly discuss that. I think that's a valid issue. But 3 to 6 months to process a routine guardianship that takes a 5-minute consent hearing is not the way these kinds of cases should be handled. There was some discussion about transferring patients without any consent. I don't think that's an appropriate solution for the sake of the patients either. Frankly, nursing homes are surveyed on whether they take patients with consent. And someone should be looking out for these patients, such as a court-appointed attorney. So we should have a process established to take a look at that. There was a question raised about temporary medical conditions. These cases do require physician certificates of incapacity, so more than just a temporary situation should be addressed.
Questions for this panel? Delegate Tolles.
So sorry, I keep harping on this issue. I know we said it's going to be massage. I just have a question for the second woman. You mentioned the social workers. Are you aware the National Association of Social Workers opposed this legislation?
I am not aware that they are opposing the legislation. I can speak on behalf of the social workers for University of Maryland and the work that they do diligently, hoping to find a family member or a friend willing to support the patient.
Just for the record, I'm sorry, social worker, they said the assignment that they, oppose this bill for one of the reasons is that the assignment of a guardian of the person results in stripping away an individual's right to self-determination. Individual under guardianship loses the right to decide where they will live, what medical care they receive, and most life decisions. And also reducing the guardianship determination to 10 days is not allowed for consideration. And they named 2 or 3 other reasons, but I definitely would encourage to reach out to the social workers if you're not aware at University of Maryland to see, because this is a National Association of Social Workers, so this is their Maryland chapter. But I just wanted to see if you were aware of that because you brought them up.
No, I was not aware of that. And of course.
Seeing no other questions, thank you all very much. We'll now go to the panels in opposition. Stephen Ellis, Judge Woodward, Magistrate Walsh, Ann Geddes, Tammy Bresnahan, Jennifer Crawley. If there's 6 of you, we'll ask you to add a chair and we'll go ahead and take all 6. But it does not look like, well, maybe we will get to 6. We'll find out. Oh, I'm sorry. We'll only have 5 in the room because 1 is virtual. So we'll be fine. That's fine. And we'll start here at my right, your left. Go right ahead.
Okay. Good afternoon. My name is Patrick Woodward, and I am retired Chief Judge of the Appellate Court of Maryland, currently serving on the Judiciary's multidisciplinary work group of guardianship stakeholders. Guardianship is an important tool, but is intended to be a last resort. Former U.S. Representative Claude Pepper said, and I quote, "The typical person subject to a guardianship has fewer rights than the typical convicted felon. They can no longer receive money or pay their bills. They can no longer marry or divorce. By appointing a guardian, the court entrusts to someone else the power to choose where they will live, what medical treatment they will get, and in rare cases, when they will die. It is, in one short sense, the most punitive civil penalty that can be levied against an American citizen with the exception, of course, of the death penalty, end quote. Because of what's at stake, respondents in guardianship cases are afforded similar rights to those afforded defendants in criminal cases. This bill would undermine those rights and would make it nearly impossible to defend against an unnecessary or overly broad guardianship or to identify alternatives to guardianship. We understand patients who remain in hospitals beyond medical necessity, stress and overburdened healthcare system, and represent a disproportionate amount of uncompensated care. Guardianship, however, is not a discharge plan. When it is used as one, the resulting guardianship is usually plenary and remains in place even if the person recovers. The result is called the hospital to guardianship pipeline. Stakeholders and others, including the work group convened by this General Assembly in 2011, have advised against the use of guardianship in discharge purposes. There are other options and factors that drive the pipeline that this bill does not address or would exacerbate. There are, however, groups, including the judiciary, actively working on this issue. In fact, the judiciary has received a federal grant to examine this pipeline. For these reasons, I respectfully urge an unfavorable report.
Good afternoon. My name is Sarah Walsh, and I'm a civil magistrate for the Circuit Court for Baltimore City. I am responsible for overseeing the adult guardianship docket in my court. Baltimore City has the largest number of adult guardianship filings in the state. This is in part due to the number of hospitals in the city. Last fiscal year, a total of 199 requests for expedited hearings in connection with medical treatment were filed across the state. 133 of those were filed in the city. Petitions for guardianship of person filed by hospitals almost always include a request for appointment of guardian of property. Most cases are not merely about consent to discharge or transfer, there is a financial piece. If the patient does not have capacity or a legal representative, such as power of attorney, a guardian of property may be needed. For guardianship of person, Maryland has a strong public guardianship system. There is no similar system for guardianship of property. Courts must turn to attorneys to serve as guardian of property when no one else is available. Most of the cases involve low-income patients, so attorneys serve on a low bono or pro bono basis. There is no source of funding to pay the attorneys, and they are not lined up at the courthouse to provide this service. Even when a guardian is appointed, the reality is that the patient will not be discharged or transferred the same day. The financial piece is often the crux of the issue, and the judiciary is actively working on rules around the specific transaction statute that Madam Vice Chair mentioned. This bill would set a 10 calendar day period wherein courts would need to hold hearings on hospital petitions. This timeline would interfere with safeguards intended to prevent unnecessary or overly restrictive guardianships. There is no one size fits all here. Each patient is different, as are their needs, resources, and options. Finally, the bill sets a mandate for virtual hearings that is unworkable. Although virtual hearings are frequently utilized, we cannot ignore that the internet access is a privilege. Not everyone has a stable internet connection or devices that would allow for meaningful participation in these proceedings. For these reasons, I respectfully urge this committee to return an unfavorable report. Thank you.
Good afternoon, Chair Clippinger and members of the House Judiciary Committee. My name is Tammy Bresnahan. I'm the Senior Director of Advocacy for AARP Maryland. And we are, I hate to say it, are asking for an unfavorable report of HB 698. We do have concerns. I will say that this is not the first time that I've heard this issue. I first worked on this issue in 2011 when I worked at the Maryland Department of Human Resources, which is now the Maryland Department of Human Services. I know that we had a work group that has studied this, and we had members of the Maryland Hospital Association, as well as members of the judiciary, local departments of social services, the local AAAs, all involved. And that was a 150-page report that was issued in 2011. And some of the recommendations is that, expedited guardianship is not the way to go. I do know in my experience with working with the local departments of social services, I myself have gotten, when I worked there, have gotten calls from hospitals where they had someone in a hospital they couldn't, discharge, and we worked on our programs and we tried to find them a placement or tried to find a relative. I know our local departments are doing that as we speak. AARP believes that this is not good public policy for an expedited guardianship. You heard what Judge Woodward said and the other magistrate, and we are here to ask you to really think hard about this and to issue an unfavorable report on House Bill 698. Thank you.
Good afternoon. Thank you, Chair Clippinger, Vice Chair Bartlett, and members of the committee. My name is Jenna Crawley. I have the distinct honor of serving as the Deputy Secretary for the Maryland Department of Aging, and I too am a social worker. As a state unit on aging, a central function of our work is advocating on the behalf of older adults and partnering with Maryland's 19 area agencies on aging, also known as the AAAs, who provide a variety of services to older adults at the local level, including serving as the court-appointed guardians of the person for adults 65 and older when no other family member or suitable guardian is available. You have our written testimony, so I'm going to highlight just a few points. First and foremost, this bill will unacceptably compromise the rights of older people and people living with disabilities, not protect them with this expedited process. An expedited guardianship process through the judicial system does not allow for consideration of the alleged incapacitated older person's autonomy and safety, or facilitate sufficient guardianship avoidance activities like identifying surrogate decision makers outside of government, or further utilizing the supportive decision-making process of which is law and was passed October 2022. For our AAAs, their public guardianship cases are increasing, and staff in most counties and in Baltimore City are already stretched thin, supporting well beyond recommended caseloads, and this bill would undoubtedly increase those. Attempting to improve our hospital systems, emergency rooms, and wait times is an important goal and one that we share. But getting there on the backs of the public guardianship system runs counter to our longevity readiness goals. Before we explore a drastic change to how public guardianship petitions flow from hospitals, we should ask, what more can we be doing to avoid them? We urge an unfavorable report on House Bill 698. Thank you.
Thank you, Mr. Chairman and committee members. I'm Ann Geddes with the Mental Health Association of Maryland. MHAMD is a nonprofit education and advocacy organization for people with mental health conditions. And I thank you for the opportunity to testify in opposition to House Bill 698. Older adults with serious mental illness would be disproportionately negatively impacted by House Bill 698. People with serious mental illness frequently have major medical conditions, which can lead to multiple hospitalizations. And because people with serious mental illness are more likely to have social emotional impairment and difficulty building and maintaining relationships, and because of stigma, they are less likely to have close friends or family members who can be identified to take care of the specific activities of daily living that the person may need that the person may need help with on discharge. In addition, when people with serious mental illness are placed into guardianship, they are more frequently placed into public guardianship, which is not ideal, especially when the public guardian is responsible for many people. We know that guardianship should be a last resort and avoided if at all possible. That's been touched on. And I just want to add that the passage of 698 at this point would be premature. In 2021, the Maryland Judiciary received a 1.1 million grant from the U.S. Department of Health and Human Services to study how to reduce the healthcare to guardianship pipeline. The grant will end at the end of this year, at which point the group working on implementation will issue a guidebook for healthcare organizations. We encourage the Maryland legislature to review the guidebook before taking steps such as the one proposed in House Bill 698. For these reasons, MHAMD opposes House Bill 698 and urges an unfavorable report.
Ms. Ellis, please, for 2 minutes. Ms. Ellis.
Hi, my name is Savannah Ellis. I'm the State Long-Term Care Ombudsman. I'm the advocate for those in nursing homes and assisted living facilities. I appreciate the opportunity to testify on this important bill and urge an unfavorable report. It is critical that individuals have a right to make informed decisions about their care. Guardianship should only be explored as a last resort, since it takes the decision-making rights away from the individual. The Long-Term Care Ombudsman Program has seen cases where guardianship was granted when an individual was delirious and then temporarily unable to make their own decisions. Once the individual recovered from their illness, they were able to make their own decisions. And in one case, the court-appointed guardian had placed them in a nursing home and worked together with the guardian of property that was also appointed during the time. The individual's family home was sold, and when the individual, and it wasn't needed because the individual had Medicare, which doesn't require a spend down. When they were able to make their own decisions and consulted with our office, it was too late. Their family home was gone. They probably didn't need to be in a nursing home in the first place. This bill is concerning for many reasons, including the 10-day stay may not be long enough for the individual, their attorney, and other interested parties to prepare and to participate in the guardianship process. It may take more than 10 days to find the family and friends of an individual and to give them the notice of the situation, including information about the court hearing and legal process. Additionally, time is needed to determine if there's any advanced care planning documentation, including a healthcare agent document, living will, or financial power of attorney documents. It also takes time to appoint counsel for the person. Once appointed, the attorney needs time to prepare for this important work, including looking at less restrictive alternatives such as surrogacy and supported decision-making. Additionally, the default for hearings should be in person, and virtual hearings should be requested if needed. There are many issues for individuals with disabilities using virtual platforms, including accessibility issues. For instance, it is often difficult for an individual to use the medium effectively. There are issues with connectivity, and if there are communication barriers, such as speech, hearing, and cognitive deficits, these platforms are not an effective means of communication. You have my written testimony. I urge a favorable report for this bill. Thank you so much.
Questions for this panel? Make sure I get it right this time. All right. Thank you very much. That concludes the testimony on 698. Just trying to know that Delegate Buckle has another bill in another committee, and we were trying to, and there he is. He has a bill with 2 witnesses. We're going to try and do this fairly quickly, committee. We'll find out if that actually works or not. House Bill 528. Delegate Buckle, Juliet Fisher, please.
I'm not sure if she's here or
Yes,
not.
she is.
Oh, there she is. There she is. How are you?
Nice to see you.
Good afternoon, Mr. Chairman, Ms. Vice Chairman, and members of the committee. I appreciate you taking our bill at this time. For the record, Delegate Jason Buckle, House Bill 528. It's a really a pretty simple bill. A couple of years ago, I served along with other members of the legislature on the task force regarding orphans courts and orphans courts reform. This was one of the recommendations that everyone sort of globally agreed with. It's a crossfire of Senator West's bill, who also served on the committee. Essentially, the orphans courts are sort of a patchwork of how they allow or don't allow people who are active attorneys to serve as orphans court judges. Obviously, when you become a district court judge, circuit court judge, you give up the totality of your law practice. Different counties, because their orphans courts are organized differently, have some different rules, as you can see from the fiscal note. What this bill would do is create uniformity across the state for the requirements for someone to be an orphans court judge while maintaining a practice of law. And what it does is it says essentially you cannot maintain a private practice of law while you are an orphans court judge if your practice involves, or you can't take matters civil or criminal that involve estate-related matters. So you could take a criminal matter about someone who allegedly stole from an estate. And while you're the orphans court judge, you may have to also perhaps deal with the probate repercussions of that. You could take a civil matter involving, something that involves something collateral to the estate. What this bill would do is it has a really great dual purpose. It gives us uniformity, so we don't have this patchwork quilt of restrictions and regulations across our 24 jurisdictions. And it also enables attorneys who most orphans court jurisdictions do not pay the orphans court judges a whole heck of a lot of money. And it is very difficult to get people who have the legal acumen to do the job to want to serve, because they would have to forfeit the entirety of their law practice. What this does is to say, listen, you do not have to forfeit the entirety of your law practice, but we have very strict guardrails of what you can do and what you can't do. And the goal of the legislation, again, is uniformity. And it's also to enable and encourage people who would have the background to do these jobs very well to be able to run for them if selected by their constituencies, or in some counties appointed. They have the ability to serve while not giving up everything they do. It would be similar for us as legislators here that said, if you become a legislator, you can't maintain another job. Like, you just can't work because you're a legislator. If you're a real estate broker, you can't come to the legislature and know anything about real estate. That wouldn't make any sense for them, for us, and it doesn't make any sense for them. So I believe that it's universally favorable. I don't think anyone's opposed to the bill. And I think that the legal community and the orphans court community and the Register of Wills community all believe that this would be a better result for the state. So thank you for your consideration of the bill.
Thank you. Good afternoon, Chairman Clippinger, members of the committee. I do want to let you all know that this already has passed out of JPR and the Senate. We're waiting for this committee for a favorable report, hopefully. I am Juliette Fisher, a judge of the Baltimore County Orphans Court, which sees the probate and administration of all estates in Baltimore County, as well as handling guardianships of minors' property. Nothing to do with your last bill, though. I am here on behalf of myself and Judge Frank, who supports the passage of House Bill 528. In 2022, as Delegate Buckle said, a task force to study the Orphans Court was created, and one of the recommendations of the task force was to allow more attorneys to run to be Orphans Court judges, which is a part-time position, similar to the legislature. This is the proposed bill that would do exactly that. Currently, the judges in Baltimore City, Baltimore County, Prince George's County, and Calvert County, who are attorneys, are allowed to continue to practice law part-time, as long as that practice does not encompass any subject matter that could be heard under the jurisdiction of the Orphans Court, so that there is no conflict of interest. That is exactly what I do and other judges in these jurisdictions are currently doing, and it has been working extremely well. In all of those jurisdictions, except for Calvert, the judges are required to be attorneys. Currently in Calvert County, their Orphans Court consists of 2 attorney judges and 1 lay judge. In most of the other jurisdictions, attorneys are not willing to run to be part-time Orphans Court judges, as it requires them to give up their entire law practice. There's been a push to have more attorney judges in these jurisdictions, but the willingness of attorneys to serve as Orphans Court judges will not be known unless this bill is successful. The bill does create statewide uniformity in the abilities of attorneys to become Orphans Court judges, while only having to refrain from practicing estates, trust, and guardianship law. I personally believe that the passage of this bill will create more opportunities to have legal professionals acting as part-time Orphans Court judges, and will address the recommendations of the task force.
Thank you, Mr. Chairman. Thank you, Delegate and panel, for coming in to testify. My question is, since you, Delegate, since you talked about running for a delegate and it's being a part-time position, and if one of the stipulations of being a delegate was that you had to give up something else or you couldn't work somewhere else, would you still run to be a delegate?
You know, my heart.
No, it's just a yes or no. I mean,
no, my
good.
child's college savings plan would sacrifice.
But good. So you have people that are sitting as Orphans Court judges right now. Is that correct?
Sure.
And they ran for office?
Very few actual attorneys, as Judge Fisher indicated.
About the attorneys, I'm asking the people who
ran. People who run for Orphans Court all over the state without any legal background. Yes.
No, the question I asked was, the people who run that are Orphans Court judges now, do they run for office?
Yes.
Yes.
So they know when they run for office that they will be prohibited from doing legal work.
Except in the jurisdictions that Judge Fisher just indicated, which includes yours.
Which includes mine.
Right.
Okay. So if I run for an office that I agree that I cannot be practicing law and I win, shouldn't I already know that I've agreed to that?
That's why hardly anyone does it. I agree with you. I guess my point would be.
That's not, you keep answering questions that I didn't ask.
No, you're saying if you ran and you knew that you couldn't practice law, will you ask for that? What I'm telling you is, I don't know of anyone who's done that. I don't know of anyone who's a sitting attorney who has run in any of the other 19, 20 jurisdictions that have that law anywhere. So the gentleman sitting next to you is from Washington County. there are no Washington County attorneys who have run for the Washington County Orphans Court in recent memory, because they would have to give up the entirety of their law practice and they would go bankrupt, because I think in Washington County, you pay an orphans court judge about $15,000 a year. So in Baltimore City, you can maintain both. And so they do that in Baltimore City, but not in the vast majority of the other jurisdictions.
I'm hearing clues, so thank you so very much.
Thank you.
Thank you, Mr. Chair. Thank you for bringing this bill. Can you kind of follow up on that line of questioning and give us a little bit more information about who is going to benefit? I think we talked about a lot in the last line of questioning, the current law and what's happening now. But what are the goals and like, what do you see happening in the orphans court and in our communities if this bill were to pass?
I think Judge Fisher has some good insight into that. If you
Yeah, I've been seeking this in the past. There's been some push for to be only attorney judges in jurisdictions. In the small jurisdictions, you're talking about Garrett County and all these other really small jurisdictions on the Eastern Shore. There's not enough attorneys. They're not willing to give up their practice. So you have business people, you have people who might be retired, you have people who don't have the necessary ability. A lot of these cases in Baltimore County, we sit full-time 5 days a week. Same with Baltimore City and some other jurisdictions. So it's a little bit different, but we don't all sit at the same time. So we have the opportunity to practice law. Our goal for the orphans court judges, as well as the legislators and the task force, is to make the bench as good and strong as it can be. There's cases that I hear that are 4-day challenges to wills where I'm ruling on evidence and writing long opinions. In the smaller jurisdictions, they don't have as much of that, but it would be really helpful for someone who has a background in evidence and in opinion writing and things of that nature. There's a lot of education that we provide to them, but it still would be preferable if some legal professionals ran for those offices. So this is just really encouraging people to be able to do that.
It sounds like not only encouraging, but allowing people who already have the skills, the background, the education to then serve our communities in that capacity.
the simplest way I can say it is it puts everyone on the same footing. Everybody plays by the same rules in all 24 jurisdictions, as opposed to what we have now, where some jurisdictions you can and some jurisdictions you can't, and it results in a complete, patchwork quilt.
Thank you, Mr. Chairman. Thank you again. Delegate, I got good news that just came in. I have to be exempt from your vote. So good luck on your bill.
Well, I did not know that, but I will take that in the spirit to which it is intended. Thank you, my friend.
Okay. Delegate Valentine.
I do have two questions. This bill does not prohibit those that are not attorneys from running. And the second question is with it pertaining to staff, and you may not know this, either of you, say Garrett County or some of the more rural counties, there are staff or support staff for these, or these decisions and a lot of this work being done simply by the judges themselves?
I can tell you that in most of the jurisdictions that I'm familiar with, smaller ones, the staff, so to speak, is really the Register of Wills office. So the Register of Wills office has people that are involved.
I have 2 full-time staff. I often have a law student intern as well as 2 full-time staff. It depends on the jurisdiction. I know the big jurisdictions, you all need to, there's a lot of moving parts. The smaller jurisdictions, sometimes they have the Register of Wills staff, they have other staff members, or they have part-time staff.
Right. It's rare, I would think you would find to have, counties with less than 150,000 people. I think it would 175, maybe even Carroll County. I think it would be rare for the orphans court to have full-time staff of their own. They usually rely on the Register of Wills to give them some guidance.
Seeing a question at the end, Delegate Phillips.
Thank you. I couldn't go without asking my my judge from Baltimore County a question. So Judge Fisher, thank you. In terms of the commonality of having attorneys participate as judges in the orphans court, at the end of the day, would you suggest that that was best for the communities in which currently we may not have attorneys? Just a simple question.
Yeah, it's a role reversal right here because Delegate Phillips appears in front of me sometimes. So I think that it's preferable. I think in the small jurisdictions, it's impossible in Garrett County where you might have 8 attorneys to get 3 people who are willing to be orphans court judges, especially if they had to give up their whole practice, which is the problem. I think the more we can encourage people with legal backgrounds to take those positions, in a lot of the jurisdictions, it's considered more of a people's court, and the very difficult things go to the circuit court. But we are more expeditious, we get cases in and out, and it's a little bit more in those jurisdictions, a way for people to have their family matters handled in an appropriate form. But more legal knowledge, I always support that.
Do you think it might help us statewide if we provided some minimal level of compensation and said across the board, every jurisdiction ought to have a minimal level of compensation and allow attorneys to have, a practice outside of a state and trust?
I think there's always more reforms needed. I am really supportive of reforms to the orphans court. I love the orphans court. I don't want to be a circuit or district court. I love that job. I like the type of law. I like the people that we reach. But I think that potentially it should be considered part of the judiciary. We're county judges instead of state judges, so our salaries aren't set in the same fashion. I think even though we're held to the same standards of ethics and everything else, judicial education, I think if we had our salaries reviewed by the judiciary, the Maryland State Judiciary and the Judicial Compensation Board, that might be an appropriate forum for that. It is hard based on the number of estates and the amount of hours. So there is a difficult position to put everyone in the same playing field.
Yeah, and I would say, Delegate Phillips, we talk about this a lot in the task force, and we talk about maybe regionalizing some of it. So the smaller counties, smaller jurisdictions could have a set of orphans court judges, or I know orphans court judge who sat, in the old style in circuit and went in a 3 or 4 county radius, so that they would ultimately have about the same workload overall as someone in one of the larger counties, and therefore could be compensated. Those were ideas that were put forth. It's more contentious than what, behind the scenes, people are like, I don't know, I don't want to give up my elected job, but this is, we think, a simple way to sort of help increase the pool of people who could perform these valuable jobs.
Thank you.
All right. Seeing no further questions, thank you very much.
Thank you, Mr. Chairman. I appreciate it.
Thank you.
That concludes the testimony on House Bill 528. We're moving around the order here a little bit, but we'll go to House Bill 595, but then we'll go to 677 next after 595. So House Bill 595 is Joshua Auerbach here. There he is. Come on up. And we will hear from you for 3 minutes. This was put in at the request of the Office of the Attorney General.
Thank you. Good afternoon, Mr. Chair, members of the committee. My name is Josh Auerbach. I've been a lawyer in the Office of the Attorney General for most of the last 17 years. And in recent years, my work has focused to a great extent on the enforcement of civil regulatory statutes. For me, in particular, the Consumer Protection Act, but the bill that I'm here to talk about would apply to the Securities Act, the Antitrust Act, and other law that I'll get a chance to talk about a little bit. House Bill 595 clarifies that the 1-year limit set forth in Section 5107 of the Courts and Judicial Proceedings article does not apply to OAG civil regulatory enforcement. It's already clear, as a result of decisions of the Appellate Court of Maryland, that Section 5107 doesn't apply when the Attorney General initiates an enforcement action in administrative proceedings. House Bill 595 would clarify that Section 5107 doesn't apply in other enforcement contexts, like when the Attorney General initiates an enforcement action in court, as opposed to administrative proceedings. The reason why clarification would be helpful is a 1989 decision from the U.S. District Court in a case called Attorney General versus Dixon. On the issue here, the Dixon case was wrongly decided. Dixon has been criticized at least twice on other grounds by Maryland appellate courts. No Maryland appellate court has followed it, but the defendants continue to cite it up until today. And there are several reasons why the Dixon case was wrongly decided, and why it shouldn't apply. Why Section 5107 doesn't and shouldn't apply to Attorney General civil regulatory enforcement. First, Section 5107 was never intended to apply to civil regulatory enforcement. How do we know that? This section 5107 is in fact 18th century law. Its roots trace back to 1777. Your predecessors from 1777 could not have intended this provision to apply, for example, to cases involving complex consumer fraud, predatory lending, securities fraud, because those concepts didn't exist back then. There wasn't anything like civil regulation as we know it today. Second, this is an equally important reason. The statutes that we're talking about here, again, the Consumer Protection Act, the Antitrust Act, the Securities Act, are comprehensive in nature. These statutes have their own extensive, detailed investigation and enforcement provisions. And in particular, all the statutes I mentioned and others provide detailed instructions with respect to penalties. Last year's civil rights law is very similar. Section 5107 isn't mentioned in any of these statutes. There's not a hint in the legislative history that Section 5107 was intended to limit enforcement of these statutes. And if your 21st and 20th century predecessors had intended for enforcement of these comprehensive statutes to be subject to an 18th century limitation that resides in a totally different part of the code, they would have said so. My time's up. I think I'll defer to questions. I guess one other thing I would like to say, it's a third important reason.
Well, okay. Yeah, you've got past your 3 minutes. I'm sorry. We're going to stop right there. We'll take questions and maybe somebody will ask you what you were about to say, perhaps, but Delegate Kaufman.
Yes, I'm reading the testimony of the Property and Casualty Association folks. It may come as no surprise to you, sir, that they're opposed to the bill. And they say that this extension of the statute of limitations is unfair because it disadvantages businesses because you have the power of the offices, but civil defendants will have trouble finding exculpatory documents. Witnesses will have moved on in their lives. And so I just wanted to give you a chance to respond about the alleged unfairness to civil defendants. And also, this may be in your written testimony, and I'm sorry if it is, but I didn't see it. How many other states have extended their statute of limitation in this area? Because the property and casualty folks tend to think that the sky will fall, and I just want to see how common it is for this extended statute.
Thank you for the question. Let me answer the second question first. What I know well, the only statute I know well nationally is the Consumer Protection Act, and I can say that the majority of our colleagues in other states, there's no statute of limitations applicable to AG consumer protection enforcement actions in other states. And so, in terms of the Consumer Protection Act, I can tell you this would make us more like the majority of other states. In terms of the sky will fall concerns, there are reasons why there isn't a history of the Attorney General bringing stale claims. There are other limitations built into the structure of these statutes. The Consumer Protection Act, again, is the one I know best. If you look at Section 13410 of the Commercial Law article, which is the instructions on penalties, there are factors to be considered in the imposition of penalties, including the good faith of the violator, the history, and penalties wouldn't be imposed because of those factors in a case where 10 years ago a business did something wrong and there's been no recurrence of that conduct since then. In addition, it's hard to prove a case from 10 years ago. So this limitation already doesn't apply to administrative enforcement actions. There isn't a history of stale actions being brought, and there are limitations built into the structure of the act that would make it very difficult, impracticable to bring a stale case.
Thank you. And quick follow-up, just out of curiosity, because you mentioned this would bring Maryland into the majority of the states, sir. And, I'm trying to be fair to both sides, but from your counterparts in other states, are you hearing or reading newspaper articles about a mass number of businesses having to close or things of that nature because the Chamber of Commerce is also opposed. I'm trying to figure out how much is hyperbole and how much is news. So have you heard about mass business closures as a result of this in other states?
Not at all. I'm not aware of any problem resulting from old enforcement cases being brought by consumer protection divisions in other states. Thank you.
Excuse me, thank you, Mr. Chair. I think this is a quick question. I'm looking at the written testimony from the Maryland Chamber of Commerce. And as a business owner, I kind of like the answer to this too. They actually ask a question, and if it's a legitimate question, please answer it. And it says, could the Attorney General enforce a civil action a previous Attorney General chose not to enforce, although the statute of limitations has passed? Is that even a legitimate question?
There are a lot of, I think, incorrect premises in that question. So, I mean, first of all, as I said, the appellate courts have said for a couple decades that this statute doesn't apply to administrative enforcement. So, and most of our enforcement work is done through the administrative process. So what we're asking for is a clarification that would make the rule the same across different enforcement contexts. I think it's a theoretical matter. I mean, a decision not to bring a case is a discretionary decision that a subsequent Attorney General could say, actually, I think there's something important here that we ought to do. So I don't think deciding not to bring a case is binding on a subsequent Attorney General. But as I said, I think there are, in terms of time, there are these limits built into these statutes, not just the Consumer Protection Act, but the others, that make it very unlikely that some stale action is going to be brought, make it very unlikely that penalties would be imposed in a stale action, and then make it hard to prove an old case. Thank you.
So two things that you just said that just give me some pause. First is that there's no history of stale actions being attempted to be rebirthed or to bring them up again, and that a decision by a previous Attorney General would not be binding on a future Attorney General. So what's to say that the goal of either this or the philosophy of an AG is to use legislation like this to actually figure out a way to resurrect stale actions and to be able to then say, well, I don't like what that previous Attorney General did, so I'm going to bring up this action that they decided not to. Aren't you giving yourself the authority to then reverse exactly what you just said is probably kind of the history of what happened?
I mean, I think the change that the clarification we're looking for here is a pretty modest one, and I'm not sure that it really raises the concern that you're raising. I mean, like as I said, this is the law with respect to administrative enforcement. Where there's a little bit of lack of clarity, it relates only to penalties. It doesn't relate to enforcement actions in general. And so what we hope to achieve here is to clarify that in these other contexts, this provision, which the point I'd hope to make is that it really makes, it can't be for this kind of work. Our view is it can't be for this kind of work. We're talking about complex consumer fraud, predatory lending. It didn't surprise me when I learned this is from 1777, because it's been obvious to those of us who do this work that it can't be that a 1-year limit from the occurrence of the offense should apply to complex consumer fraud.
Right. And I understand. I mean, I understand why you want it. My issue is that if you're saying, well, there's not a history of us ever really bringing up stale cases, but if we give you more tools to be able to do that, what's to stop a future AG who's not bound by the decisions of previous to then start using this tool? But let me ask you just on a specific question. So I don't think this is administrative. I think this would be sort of in the circuit court, but let's say that the Attorney General decided to go after a bank, for example, for garnishing $6,003 because they have a limit that they're only allowed to garnish a maximum of $6,000, right? Because on a law that you guys helped us pass a number of years ago. And they mistakenly took an extra money. They didn't do anything because it was a nominal amount of money. But the next AG decides, you know what? Because the bank was rightfully supposed to be able to get 25,000 or 28,000 within the circuit court's jurisdiction. And they only took 6,000 plus a few dollars. Now the AG says, well, 6 years, 8 years, 10 years later, they don't like what this bank has been doing. And they think that so let's just go after them after this so that we can settle, we can deal with them. It seems to me like you're giving the authority to be able to start to go after these guys.
I think, Delegate Cardin, the best answer I can give to your question, I think it's a good answer to your prior question, which I probably didn't give a good answer to, is in section 13.410 of the commercial law article. That's where your predecessors gave us instructions on when penalties may be imposed. And, it talks about the good faith of the violator, the history of violations. And so I take the thrust of your question to be, it's a pretty chintzy little violation. And what section 13.410 says is, this is not a good case for penalties. And a court, if penalties were, a court would not impose penalties or uphold an imposition of penalties, at least severe penalties in the kind of case you're talking about.
Cost of litigation to the state is nominal, but the cost of litigation on this matter for the defendant could be extraordinary. And last question, what authority did we give you last year to be able to, we gave you some authority to be able to go after on civil action, it was civil rights. Civil rights, right?
Yeah.
So now you want to be able to say, well, we should be able to not just, are you worried that it's those new powers that we've given you, that you now need to make sure you have unlimited amount of time, or is that already covered in the administrative side?
I think the civil rights law is a good example of what I'm talking about. So it's in Title 20 of the state government article. There's a whole subtitle there that with very specific detailed instructions about what we are to do in the investigation and enforcement of violations of civil rights law, including very specific instructions about penalties. And it can't be, yes, there may be some civil rights violation that's kind of like a parking ticket or a traffic ticket. You see it, you go, but in the real world, in the work that we do, it can't be to us that there's a year from the occurrence of the offense to be able to impose those penalties that the legislature gave us authority to impose or to seek. 1 year makes no sense. And so, yeah, there are certain cases in which that penalty authority is not meaningful if, as some defendants argue, this 1 year limit from the occurrence of the offense is applicable.
In 2023, you asked for new powers. In 2024, you want to extend those powers indefinitely.
Not extend. I think we want to clarify again. This is an issue on which we've prevailed in the courts for several decades. But what we're seeking is clarification in other enforcement contexts outside the administrative process.
Thank you, Mr. Chair.
Seeing no further questions, thank you very much. We'll hear now from Bob Enton in opposition.
Thank you very much, Mr. Chairman, members of the committee. Robert Enton, testifying today on behalf of both the Maryland Bankers Association and the American Property Casualty Insurers Association. And we are in opposition to the bill. I've had a number of conversations with Mr. Sakamoto Wengel from the Attorney General's office about this piece of legislation. Initially, when I looked at it, I didn't even really focus too much on the language at the very end of the bill. Most of the bill was introduced dealt with antitrust provisions. And there was an exemption in the antitrust statute for banks and insurance companies. But then as I looked at it closer and I picked up on the language at the end of the bill, the way I read it, it basically says that if I did something 30 years ago, the AG could then come and seek a penalty against me for something that happened 30 years ago. It removes any statute of limitations whatsoever on enforcement actions by the Attorney General. Now, you know, we have a law that's on the books that says if you want to have a specific statute of limitations different than what's in 5107, nothing stops you from doing that. But if there's no other specific statute, 5107 basically is pretty straightforward. It says the statute of limitations is 1 year. So I'm not sure, you know, what the definition of civil enforcement is. But that's a tremendous concern to the companies that I represent. And frankly, I think most people didn't catch this. I think if most business groups had caught this language at the end and understood what it did, you'd probably have dozens of witnesses here today. I know the chamber has signed up in opposition to the bill. I'm happy to work with the Attorney General, but I just think having a blanket a law which just blanket in a blanket fashion says there is no statute of limitations whatsoever on these actions is just not a good idea and is contrary to the whole notion of having a statute of limitations. Thank you.
Thank you, Mr. Chairman. Thank you for coming in to testify. I had thought about this, and my perspective was that the heir of someone might be found liable if you have an open-ended type of situation like this. So what about if we came up with a number, but I know that you're going to say how we're going to pick this arbitrary number, you know, the 10 years, 20 years, 50 years, 100 years. So I just wanted to get your comment on it.
So I think as most of the people in this committee know, in particular, and particularly the lawyers on this committee know, you know, typically a statute of limitations in Maryland for bringing a cause of action is 3 years. And, you know, if it's under seal, it's longer. And if it's this is that, sometimes it's 4 years. But, you know, it's funny, in preparation for the hearing, I Googled statute of limitations to see what was online about statutes of limitations. And statutes of limitations are there because as a matter of public policy, if you don't want to go back so far that witnesses are no longer available, that evidence is no longer available, if you're going to bring a cause of action, then you've got to do it within a prescribed period of time. And once again, generally, that prescribed period of time is 3 years. So if there's a lower number, they want to have a specific number. If they wanted to specify maybe what kinds of enforcements they were talking about, but just to have this broad statute that says for any enforcement action by the Attorney General, there is no statute of limitations whatsoever. My clients are concerned about it.
Thank you, Mr. Chairman. Since you did your research, can you tell us something that might not have a statute of limitations?
I'm sorry, can you say that again?
Since you did your research, could you tell us something that might not have a statute of limitations?
I'm not really aware in my research.
Civil or
I didn't come across anything where there was no statute of limitations. Maybe it's out there. I didn't see it.
Murder, I think. No statute of limitations.
Once again, we're talking about civil actions.
I said civil or criminal. You didn't listen. Okay. Right. Thank you.
Okay.
Further questions? Seeing none, thank you very much. That concludes the testimony on House Bill 595. We are waiting. We had members of the administration here to do 583, but they had to go upstairs to the Health and Government Operations Committee. So we're going to keep going. We have people with us. We do. From Ways and Means Committee who are here to hear House Bill 677. Delegate Cardin, go on up. It's Delegate Cardin and Juliet Fisher. People from Ways and Means have questions.
Just don't ask me. You can ask her, don't ask me. Oh, I left my computer. Thank you, Mr. Chair, members of the committee, John Cardin on behalf of House Bill 677, asking for a favorable report. I left my computer with my notes on up at my desk, but I will do this. I will do this by memory. This bill moves the election of orphans court judges to a nonpartisan election. There is no reason, you know, that I have come up here asking you to eliminate circuit court judges and spoken about the issue of judges getting involved in partisan politics. Now, I think it creates a problem with the integrity of the judiciary. This is a similar situation where I don't believe that the orphans court judges should have any involvement in partisanship or partisan elections. It just creates a nonpartisan election for orphans court judges. And I'll stop there and let my witness, who's far more versed in orphans court judges elections, testify. Thank you.
Again, I'm Juliette Fisher, Judge of the Orphanage Court, and I'm here on behalf of myself and Judge Frank, who support the passage of House Bill 677. The Orphans Court consists in almost every jurisdiction of 3 judges who are elected every 4 years. Currently, the only judges in the entire state that participate in partisan elections are the judges of the Orphans Courts. In 2022, a task force to study the Orphans Courts was created. One of the recommendations of the task force was to make the election of orphans court judges less political by allowing them to engage in nonpartisan elections, which is exactly what this bill would do. Previously, my court has sought this change. Actually, I think this might be the 4th time that I've been here on this bill in an effort to make this judicial office less political and therefore more in line with the rest of the judiciary, and more specifically, in this case, the circuit court judges, each of whom cross-file for both the Democratic and Republican nominations. We had previously sought the opinion of our then Attorney General, who said, quote, "Currently, in my view, Maryland law does not require judges of the Orphans Court to register their political party when running for office. See Maryland Code Annotated Election Law, Section 5203, stating that requirements for party affiliation simply do not apply to candidates for judicial office. But historically, judges of the Orphans Court have registered their party affiliation when running for office, and according to counsel for the State Board of Elections, altering this historical practice would require a statutory change. It is exactly that change that we're seeking here today. Because the Maryland Constitution is silent on party affiliation, no constitutional amendment would be necessary. I do want to address briefly, I know the League of Women Voters brought up in the Senate that they have an issue with independents not voting in the primary. That is not something to be taken up in this bill, but if you want to consider that, you would have to amend the entirety of the bill. They would like us to run as the Board of Election members run, which is completely inappropriate for members of the judiciary. We should be running along with the only other elected judicial officials, which is currently the circuit court. Also, this bill has passed the Senate, and we're just waiting for a favorable report, hopefully from this committee. Happy to take any questions.
Thank you, Mr. Chairman.
You're
Thank you,
exempt from
Delegate.
this one too.
Well,
Delegate Conaway.
okay, happy Valentine's Day to you. Thank you, Delegate and witness, for coming and bringing this bill. Has there been any kind of problem with the affiliation of the people that are running for office that you know of?
Personally, I've been yelled at and screamed at, and I'm a neutral person. There's nothing in probate law, estates and trust article that would require me, that would make any difference if I was a Democrat or a Republican. My job that I was sworn to do and tasked to do is apply the law, and that is what I do. Party affiliation should not matter. We live in a very difficult time with partisanship. And
but you were yelled at and screamed at.
well, because I have to run for.
Excuse me, at the polls?
Yes.
And they yelled at you and screamed at you because because of your filing?
Because our party affiliation is next to our name, and it shouldn't be. As I stated, it's a historical practice. The statute, the election law is clear that no candidate for judicial office should file their party affiliation. We're judges. We shouldn't have our party affiliations there. I understand that people have a lot of different feelings about judicial elections.
Right.
I understand that the League of Women Voters would like it to be in line with.
I understand the names that you're dropping, but this happened inside of the polling?
No, outside.
Oh, outside of the poll. Well, that's different because having been elected several times, I get yelled at all the time.
But you are
taxes and things like that.
You're elected as a Democrat, whereas judges, in my estimation, what this bill does, As a judge charges when they come out on the bench, usually, not all judges do it, but they say they're not affiliated with any agency or any organization or any political party, and they shouldn't be, because they should be looking at the matter at hand based on the facts and apply the law to those facts, and not based on some sort of political agenda. And that should never be the concern. And we don't want somebody coming before, whether it's a circuit court judge, a district court judge, or an orphans court judge, and worry that they're going to make a decision on their estate, on how their estate or their money or their guardianship or whatever is going to be treated based on a preconceived notion because of political party. That should never be an issue when you're dealing with somebody who is labeled as a judge. And so this has been something that, for those of you who have been with me for a number of years, you know that I really just think this cleans that up, and it makes it make sense and gives more integrity to the judiciary. And by the way, Judge Fisher and I went to law school together. You can see that she learned all the law, and I just kind of figured out how to try and.
So that's why she's with you, because you have that affiliation.
She knows how to answer the questions better
Okay,
than
well, I thank you very much, and I was very much with you until you got into a one party ruling on the state of another party and all like that. But again, I'm exempt from this, so I thank you so very much.
Okay. Okay, thank you for bringing this bill. I had been working over the interim on a bill that would allow the unaffiliated voter the opportunity to vote in a primary only for those positions that were nonpartisan. The reason why I didn't bring the bill was because there was so much disparity in when I asked somebody from the court, the election judges, are they partisan or not? Are the judges partisan or not? Anyway, I got mixed messages back with regard to whether or not a judge was partisan, right? So I just didn't bring the bill. And I actually have one of my interns doing research to figure out whether or not a judge is really partisan or not. And I think what you're doing is clearing part of that up, and I appreciate that. But if this bill passes, is my question, would an unaffiliated voter then be able to go into a primary and request a ballot that would only have the nonpartisan positions on it, which would be then the school board and the orphans court judges?
And the circuit court judges.
And the circuit court judges.
So for the school board, I believe, and I haven't studied that, we've discussed this a lot. I would like to see independent voters be able to vote in a primary. But right now, the law that we have, this is the only judiciary that runs. This is where we should fit in. I wouldn't be necessarily opposed in next session or whenever it would be to bring a bill that would allow those two judicial positions to have that. But having us run in the same way as the school board, which is slightly different than the circuit court judges, seems inappropriate when you're supposed to be lumping the judiciary into the same fashion. Our goal this year, and for the last several years when I've tried to do this, is to put ourselves in line with the judiciary. Justice Fader was here. I've met with him on the vice chair of the Orphans Court Conference about this, and he, not on the, not speaking for the judiciary, seemed on board with it. The confusion is that it says we shouldn't register a party affiliation, and yet there we are lumped in by the Board of Elections being required to. So this cleans up that, as Delegate Cardin said. I think that there'll probably be more election reform, but for this year, it's appropriate to have us in this bill, and then to look later on at how you can bring the independent voters into voting for those positions. Because I think the whole section might need a second look, but.
This brings me back to my Ways and Means days. And I'll tell you what I think that our friends from Ways and Means might think about is that if you allow non-affiliated independent voters vote in a primary where they're only voting for certain positions and not for others, that there's going to be a tremendous amount of confusion, and that could cause issues. Why can't I vote for delegates when I'm voting for judges? They don't realize that they're only allowed to vote for a few positions. I'm not saying that that's something that we don't want to tackle, and I'm all about it. I'm just saying that might be something that our friends from Ways and Means might.
There's a lot of confusion. This is an attempt to take us out of the partisan, put us with the judiciary, and then think later about other reforms that might be appropriate.
Voter segment in Maryland.
I agree.
All right, before we take too many more questions here, the next bill is actually going to be 583. So we're going to finish hearing this one and then we'll go back to 583. But in this, what was supposed to be a short bill, now I have a question. So just to be clear, what you're saying is that they'd be unaffiliated, but they'd run in both the primary and then in the general?
The same exact way the circuit court judges do. If you're familiar with the
So
circuit
it's,
court.
let's say there was someone here today, maybe speaking right now, who thinks that's incredibly dumb. That seems to me that you're giving which is no offense to you, you're just putting it in parallel with that. But I guess my question is, why do we do that? Why should to the point of allowing independents to vote, why do we just say the Democratic primary electorate and the Republican primary electorate get to elect orphans court judges, much less, by the way, circuit court judges? This committee last term attempted to try and put the circuit court judges all in the fall, all in November, and it didn't make it all the way through. Why shouldn't it be? Why shouldn't there just be one election? If it's going to be unaffiliated, why shouldn't it be at a time when everybody can vote for them?
I think if you're going to do that, you take this whole section of the law and you alter it. For right now, it's uniformity. I clearly didn't craft that portion of the law. And we've run in partisan elections where we've had primaries and Republican or Democratic primaries that independent persons weren't voting for us in the spring anyway. And if, they potentially could vote for us in the fall, but it's generally too late. So we're not disenfranchising them any further than they currently have been. We're just clearing up the partisan, nonpartisan aspect of it. I don't discount the fact that that entire section of law might need to have a closer look, but this isn't the time or the place to do it. Put us in, and then when you reform it, we'll be in the same reform level as the circuit court judges.
All right, I won't belabor it. And but when I use the word dumb, I absolutely not directing it at the sponsor or you or anybody else. I think that if you're going to run with positions that are unaffiliated, making them run through a party primary seems very kind of odd to me, and even more so getting a result potentially based only on the Democratic and the Republican primary electorates really seems to me to be unfair, and kind of wonder why somebody hasn't sued about it.
Right.
But anyway, let's go over there to Delegate Tomlinson, and I'm staying out of your committee now forever. And Delegate Tomlinson, Delegate Moon, and then maybe somebody from Ways and Means here in a minute. We'll find out. Delegate Tomlinson.
Thank you, Mr. Chairman. Actually, I was going to say a little bit of what you just said. So, no, I agree. Because you guys are trying to mirror the circuit court, how we elect it, and it is confusing. I know. I have to explain it whenever we've got a judge. Just for example, we had two, Carroll County, no surprise, we only had Republicans running for circuit court judge, and hard to believe. and the Republican though, one Republican won on the Democrat primary ballot and the other one on the Republican primary ballot in the primary. And then the general election, the woman won who was on the Democrat ballot. She was a registered Republican, but she won, everyone was very confused because everyone's like, oh, the Democrat won. Well, no, actually everybody was a registered Republican. Anyways, point of the story is, why have you guys entertained the idea of instead modeling what you're trying to do after like Board of Education, where you just have you have 6 people running and it's just all unaffiliated, and then actually that would kind of solve what you're talking about, because independents can already vote in those elections.
So I discussed this with a lot of people over the last several years, and the consensus with all the judges that I've spoken to is that they want to be put into the judicial part of it, and then we are happy for you all to take another look at this, create a bill that encompasses all of it. But when you're talking about putting members of the judiciary instead of the way the circuit court judges run with the school board, it doesn't feel appropriate. It feels appropriate to lump the orphans court judges in with the circuit court judges. If you want to do an overhaul, we don't even have an election till 2026. So you've got plenty of time for the orphans court. The circuit court obviously runs whenever they need to. But it's something that you need to have a more deep dive with all of them. At this point, we're asking for a favorable report. As I said, it's already come out of the Senate to be included in that. I didn't draft this legislation. I agree that it's flawed, but there's also flaws, I think, with the way that the school board is elected pertaining to judges. And I'm not going to go in depth because there's other things you all need to hear today, the important things going on. So, but we would respectfully request to be added and have a favorable report. And, you know, if any of you want to have further discussions about judicial elections, including the orphans court, I'm happy to talk to anyone outside of this hearing.
Thank you, Mr. Chair. I hate to ask, but aren't we moving from one peculiar scenario to another one in this bill? I mean, you're
I think that's what the chair.
you're comparing going from where you are into the circuit court, you know, but I've asked myself oftentimes, does one register a will as a Democrat or clerk of court as a Republican? And I felt the same about the orphans court. And so in the fiscal note, there seems to be a third option here, which is, why are we electing these at all? And isn't that actually,
So
I mean,
I don't have to run again.
Well,
Perfect.
Mr. Majority Leader.
is that not a simpler solution?
Mr. Majority Leader, I've put that legislation in now for 17 years. So I am more than happy. What's that?
We avoid weird stuff.
We avoid weird stuff. I will say that one of the things that the chairman brought up, which you talk about weird, going from weird to weird, is that we have to run in a primary, and then if we win, run in the general. Judges have to run in 2 primaries, and if they lose one of those primaries, then they have to run in the general. They have to run in more elections than politicians. That is ridiculous, right? That is totally ridiculous. And so that's, but the fact is that they shouldn't be affiliated with Democrats or Republicans. So, we just want to we're just trying to correct this small thing, turning it from one inappropriate thing to maybe a weird thing. And then next year, when I put in my elimination of elections, we can then move this whole thing out of the election article altogether.
Okay, then. Anybody from Ways and Means got a question at all? Aren't you happy you stopped by? Thank you all very much. That appears to conclude the testimony now on House Bill 6. Was that 677? Yes, House Bill. No, that was, yeah, House Bill 677. Thank you very much. All right. Well, this is what we do. Thanks again to our friends from Ways and Means for stopping by. Please don't, please come back if you can stand it. Let's go to we have the administration, I think, for House Bill 583. We'll go in what will be an amazing form of whiplash in between these 2 bills. We'll hear from Karen Herron, Secretary Laura Herrera Scott, Kay McKnight, and Jen Policonis, please, on House Bill 583.
Good afternoon, Chairman Clippinger and Judiciary Committee members. For the record, I'm Secretary Herrera Scott, testifying in support of House Bill 583 on behalf of the Moore-Miller administration to create a Center for Firearm Violence Prevention within the Health Department. I am joined today in this panel by advocates, researchers, and community organizations who advance this work every day. I would like to take this opportunity to speak about how the establishment of the center within the department will enhance the ongoing work of these individuals, the department's current work, as well as the work of other state agencies. As reiterated in the state plan last week, one of Governor Moore's administration's top priorities is keeping our communities safe. In Maryland, we aren't sitting on the sidelines. We are tackling tough issues ahead in partnership with members of our community and the Maryland General Assembly. The department's current initiative focus on upstream public health initiatives through the behavioral health and public health administrations, as well as Medicaid. This center will coordinate our current efforts with a focus on data collection to evaluate their effectiveness and drive future interventions. It will also serve as a conduit to other state agencies and officers like the Governor's Office of Crime Prevention and Policy as they coordinate resources to improve public policy and safety. Our public health approach to violence prevention and intervention requires centering health, especially behavioral health, as the main goal for decreasing injuries and death. It identifies health as a shared value, acknowledges that violence is complex and layered, and implements evidence-based solutions and engages community, lending space for diverse voices and principles to confront and come together in a desire for change. In 2021, Maryland had a firearm injury death rate of 15.2 per 100,000 population, ranking 22nd in the country. As the vast majority of these deaths occur in young adults, this represents a significant increase in number of years life lost compared to other leading causes of death. In 2022, people ages 25 to 34 experienced the most firearm-related injuries and death. Research indicates that gun violence is not inevitable and can be prevented using public health measures, including systematic data collection, examining shared risk and protective factors, and using research-backed strategies. Evidence-based interventions exist that are scalable and sustainable. This is the work that the center will address. One key initiative that were recently launched includes a new violence prevention benefit in Medicaid. Maryland is the second state to receive approval for this program, highlighting its commitment to community well-being. Covered services include mentorship, conflict mediation, crisis intervention, referrals to certified or licensed healthcare professionals or social service providers, patient education, and screening for services for victims of violence. The benefit is currently healthcare related. Gun violence affects every part of society, and it will take every part of society to come up with solutions. Maryland is proud to be the first state to answer President Biden's call to launch a statewide Office of Violence Prevention and Intervention. We thank you, and we ask for a favorable report on House Bill 583.
I can go. Good afternoon. I'm here again. As some of you may know, my son was a 13-year-old who was shot by the 12-year-old. His name is King Douglas at the Dave & Buster's in Capitol Heights. King wasn't just a name for me. He was the heart of my family, a bright and cherished soul taken from us too soon. Since then, our lives has been filled with unimaginable sadness and grief. Every day is a struggle for me and my family without King. Our home, once filled with laughter and joy, now feels empty and silent. But our grief extends beyond our family. It touches everyone who knew and loved King. His friends, teachers, and our entire community mourn the loss of him. Despite the pain, we refuse to stay silent. We're determined to turn our tragedy into action. We're advocating for measures to reduce gun violence and keep our community safe. We believe that everyone deserves to feel secure in their homes and their community. That means promoting responsible gun ownership and supporting policies and laws that prevent firearms from falling into the wrong hands and lifting up at-risk communities. By working together, we can honor King's memories as well as others and prevent other families from experiencing the same heartbreak that I'm experiencing. I pray that we come together to create a safer and more compassionate world for all. That's why I'm here to express my unwavering support for HB 583, the bill proposing the creation of a Center for Firearm Violence Prevention and Intervention within the Maryland Department of Health. The center would play a crucial role in addressing the root causes of gun violence and implementing evidence-informed solutions. Thank you.
Would you just restate your name for the record?
JK McKnight.
Thank you.
Yes.
Good afternoon. I am Karen Herron, Executive Director of Marylanders to Prevent Gun Violence. I'm also the co-lead of the Maryland Violence Prevention Coalition, and I speak here today on behalf of both of those entities in support of SB 475. Oh, sorry, you know, the HB number, to establish a true public health approach to tackling gun violence in Maryland. The genesis of a state-level Office of Gun Violence Prevention stems from our acknowledgement that incarceration alone cannot solve this problem. When we are always tackling gun violence after it has begun or after it happens, we have begun too late. It is crucial to comprehend the needs of at-risk communities and actively engage to provide them with necessary support. This looks different in different communities. Sometimes this looks like crisis counseling or housing support or better public transportation or even access to healthy food. Being able to get into communities through the already existing infrastructure of local health departments, the Center for Firearm Violence Prevention and Intervention will be able to assess the landscape and deploy resources, manage and facilitate data collection and analysis, and so much more. This really goes beyond the financial resources that are allocated through GOCAP or that piece that is steered by our law enforcement agencies, including the Maryland Gun Center. This entity would be able to assess the whole landscape statewide and determine what exists, what is needed, what could be done better, bringing stakeholders from law enforcement, hospitals, communities, researchers, nonprofits together so that the landscape of gun violence prevention starts to become a cohesive picture. We talk frequently about the different parts of preventing and addressing gun violence as pieces of a puzzle. Think of this office as the entity that puts all of those pieces together to create something beautiful and sustainable, and that has the capacity to address those root causes that we talk so much about. We urge a favorable report.
My name is Jen Poliakonis, and I'm the Director of Policy and Programming for the Johns Hopkins Center for Gun Violence Solutions. I'm speaking here not only on behalf of the center, but also Johns Hopkins University and medicine. I want to first differentiate my own center, with the program described in the bill. Our university-based center employs expert faculty and staff to study gun violence and strengthen policy solutions at the federal and state level, not just in Maryland. The initiative established in House Bill 583 will serve as a state hub between a variety of federal, state, and local agencies to ensure that our laws are fully implemented and intervention programs are funded and evaluated. Currently, 8 states and the District of Columbia have offices of gun violence prevention. And while many of these state offices are new and the research is in its infancy, one promising example is the Safe and Successful Youth Initiative created within the Massachusetts Governor's Office that's focused on funding and coordination for youth intervention programs. Researchers compared the cities within this program to cities outside of it and found fewer rates of violent crime among youth, and it ended saving the state over $32 million annually in violent crime victimization costs. And the vision for Maryland Center is even more comprehensive. As Secretary Herrera-Scott stated, the Center for Violence Prevention and Intervention utilizes a public health approach. This means that state leaders will be able to fully understand the scope of the gun violence epidemic, which factors most put our communities at risk, and which laws and programs are most effective. Maryland has enacted an array of evidence-informed gun laws, and the creation of the center will strengthen the collaboration and enforcement of the laws currently on our books. And it's going to increase the impact of these laws. It will also ensure that key data is being shared between agencies to reduce duplicative work being conducted on the issue and to improve the results and save resources. Johns Hopkins University and Medicine respectfully requests a favorable report.
Delegate Kaufman for a question.
Yes, thank you, Madam Secretary. It's really nice to meet you. I believe this is the first time. My question is simply, I noticed that the timer went off before you had finished your thought. So do you have anything like a burning summation that you would like to give?
So yes, so.
Asked and answered.
It's really a different approach. You've heard a little bit from every single person on the panel, but it's using data and predictive analytics in a way that informs what interventions need to be deployed. For example, communities that have experienced trauma, oftentimes resources go into the community for a day, a couple of days, but that trauma and the effects of that trauma not always felt in the first 24 hours, the first 48 hours. And so really rapid tapping services and community of trauma and addressing those issues through behavioral health interventions, other community supports would be one way to address this. In addition, just thinking about innovation, working with researchers at Johns Hopkins, or even quite frankly, social media. We know that there are arguments happening in social media, and how do we leverage social media as a tool to identify who's at risk and intervene sooner. So it's a varied approach, working with everyone here at this table, including our other state agencies such as GoCap, but going upstream to address the issues before they happen. And thank you.
A quick follow-up, Mr. Chair, if I can. Thank you, very generous. We have had a lot of I've not been here long, but we've had many hour-long debates about bills that would strengthen and weaken gun safety and the Second Amendment and what it says. But as I look at your center, this does nothing to strengthen or weaken current existing gun laws. Is that correct? So that maybe some of the people that are typically on opposite sides of the gun debate might all, is it a possibility that some of the people who are typically on opposite sides of the gun debate could support this?
So this doesn't speak to gun issues per se, but the individual and the trauma that they've experienced, or their circumstances in their community that would want them to pick up a gun, and hopefully address that trauma and those adverse events earlier on, so the gun doesn't become an option for them.
Because I think all sides agree that gun violence is unfortunate. Isn't that so? Thank you, Mr. Chair.
Thank you, Mr. Chairman. Thank you, panel, for coming in to testify. Are we saying that we don't know the root cause of this gun violence? Is that what we're saying?
I'm saying that the root cause is multifactorial, and we need to have a better understanding of all the opportunities to address it upstream. So untreated behavioral health diagnosis is one example. You alluded to communities that have been underinvested, and some of the things that destabilize an underinvested community that lead to trauma and potentially gun violence. As I said, even seemingly benign arguments that get escalated that could lead to gun violence. So multifactorial, and through the center, we hope to start tackling many of those.
Seemingly benign arguments, that's opinionated, isn't it? Yes. So what do you mean at-risk community in relationship to healthy foods? That was testified to.
I think that was my testimony.
Okay, yes, I understand.
So I think it's important to remember that the gun violence in communities around the entire state, it looks different in different places. It's caused by different things in different places. And that is why having local health departments that really understand their own communities, that they can get to the root of whatever it looks like, whether it's, white men in rural areas where their suicide rates are high, or whether we're talking in the city.
No. You said healthy foods and at-risk communities, right? And I'm trying to, I live somewhat in a at-risk community, and there's a problem with quote unquote fresh foods, healthy foods. And I don't understand what relationship not having healthy foods has to gun violence.
Gotcha.
So that's the only question I was asking.
Right. I think I was using it as an example of when we are worried about putting food on the table for our children.
Thank you very much, Mr. Chairman. Thank you.
Delegate Taylor.
Thank you, Mr. Chair. Thank you, Madam Secretary, for being here, and love the idea. You mentioned that social media might be used to spread the word, to get the message out. The question is, do you think we have the courage in this administration to really tackle social media and apps that may actually inspire the gun violence, and how we might have to go after companies and apps? And I'm just wondering if we are willing to really dig that deep into the why and how potentially apps and our kids' access to information all over the internet is actually inspiring a lot of this gun violence.
So I wasn't suggesting that we go after the companies or the platforms, but how do we use the information that we can see happening on social media to prevent an event from happening? So as another data point, to take action in a particular community where we know, things are escalating just by the way and what they're posting on social media.
And I guess my question has to do with even further than that. We know that our kids are inspired and motivated, even our adults, and get their personal gratification and likes and attaboys from the phone and the internet and different applications. We may have to have the courage to go beyond what we normally do and just spread spread messages and deal with the, mental health behavior, but the root cause of it for a lot of folks is right here. And we might have to look at it from, that perspective as well, and just hoping that you will have the courage to dig that deep.
With the passage of this legislation, our goal is to really, really understand what drives violence in community and do whatever we can to intervene before that violence actually erupts.
Thank you, Mr. Chair. I'm not even sure how to frame this up. First, let me say thank you for being here. And I thank you for always talking about King. And whatever it is I'm trying to get out or ask is somewhere in there. I don't know if you saw me looking at you, I was trying to get that vibe to come back on me. So you talk about food. I've looked at this bill over and over, and I'm really trying to figure out how we're going to stop the issue of the gun violence. I see all the pieces here. And I know, Mr. Chair, that this is before I'm gonna ask you this to this. Isn't it so? He says, I'm not really asking you. That was sort of rhetorical. Someone sort of said that he doesn't like task forces and things like that. And I've grown to not like them too. Okay. Okay. You know why? Because some have an end. Okay. Remember, I wrote one. Okay. So some have an end. But in this case, here's my issue. How long do we keep looking at the same problem? Because the end result keeps happening. And we look at it, we look at the data. I don't know that you can look at data about how people feel that drive them to, especially I'm talking children particularly, doing harm to another. So, and one of the things here, because I look for this word all the time because I hear so many witnesses saying this. Can you explain to me in this, anyone, explain to me in this why the word education is missing, or did I miss it? Or where is it embedded? And I mean real education. I mean, what we do about our schools, what we do about programs for children and for folks. So what do we do about conflict resolution? Because we know guns are here, and that's what folks think, that they can shoot somebody. Would you agree? They can shoot, especially for children, that they can shoot somebody. It's like they'll jump back up after they've been shot, but they don't. it's something missing and we've stopped talking about it. And I'm trying to find it in this bill and in every bill. Can someone up there help me with this?
I think I'll speak on it as a crime victim. I think education is very important. I think that we do need to bring that back into the school systems, as I stated before, because a lot of kids are not educated about it, what crimes are. You would think that it's common sense that a child knows not to do certain things, but some of them are not taught that. Some of them are taught to fight back and to shoot when upset, unfortunately. So I do think that we should bring that into the school systems with education, like we do sex education. We should be able to talk about mental health, mental illness and trauma and get to the root issues. So.
And if I can add.
Not mentally ill at the beginning. All of our children running around are not mentally ill. But our society and all of the issues that children have in it now will make all of us mentally ill. At any given moment, all of us are mentally ill.
If I may add, I mean, kids manifest trauma in lots of different ways, and they're not necessarily just sad or depressed. They may be angry, they might be aggressive, they might bully, but kids act out in a variety of ways. And part of the center would be helping to get those children treated sooner so that maybe perhaps they were victims of trauma by virtue of where they lived or experienced trauma. I don't know if King had a sibling, but victims of trauma, and they manifest that trauma differently. So through the center, that would be another thing to address, because what happens to our kids that act out because they haven't processed their feelings is they get in trouble in school, they might or might not get suspended, they might or might not get kicked out, and then that starts this downhill cascade.
So should not some of what you're talking about happen beyond wherever the center is, and there be a relationship with schools and community schools and churches and all of those places? That
absolutely all of the above. And we certainly consider MSDE to be a partner. We are already, through the Behavioral Health Administration and the Public Health Administration, have started some of that work. But the center is the opportunity to really put some of the work we've done on steroids, as well as the data piece and the partnership at the local level, et cetera. So it's an opportunity to do more over and above what the department has done, and certainly working with everyone on this panel and other state agencies that are doing this work.
So I signed on to this because sometimes I see things that are not there. So I clearly saw on these pages what you just described, but they're really not on these pages. So how do we apprise MSDE, who had to be pulled out of the whole juvenile justice piece because they didn't get that? So how do we let these various groups and these people say, this is your piece, this is when you go into the schools, these are the people who we're identifying through what happens here to go into the wherevers to have conversations? Because I'm going to say again, our children are not born with this anger and the trauma, right? Would you agree? I mean, that's not how they come out. So, or how we come out. So what do we do, and where do we do it, and where is it here? I just want to know where to plop it in. So if someone asks the question, I say it's right here, that says that somebody is going to go in somewhere before the children are traumatized, or if and when they become traumatized, they already know and their parents already know, here's a place or places where you can get support so they don't become so angry that in a playground or a recreational situation, they think this is the answer.
I think the language of the bill as it's written today was meant to provide a very broad framework to allow all those pieces that you're talking about to happen, but also being careful not to be dictating what the data and analysis and needs-based assessments are going to first accomplish, which is sort of task one for the Department of Health, so that we make sure that we're moving forward in a way that's really being informed by what is happening. I'm 100% all of the things that you're talking about, and every expectation that in many communities, that's exactly how it's going to need to play out. But I think the language is trying to make sure that it's not dictating things that we think rather than what we know, if that makes any sense.
I understand what you're saying, but it's not, as a lifelong educator until I got on Judiciary Committee.
Question. Delegate Pasteur.
I'm just trying to
With
understand.
respect.
I need you to, okay, never mind, because.
If
right.
you'd like to engage in the more in a wider range of conversation, that's fine, but for now, we need to.
I get it. I understand. And I've been always waiting for a wider conversation that never seems to come, and everything continues the same. And you have a child who is a victim, and other people have children who are victim, and we're still talking about waiting. Okay, thank you.
Delegate Williams, Jay Grammer, then Eric.
Thank you, Mr. Chair. I feel like kind of bad. I had a comment. I just see the red shirts in the back of the individuals, Moms Demand Action, who I know are not here to testify, but just here in solidarity and support. But my question was more so for the Secretary. One, thank you for being here to testify on this bill and the governor's initiative with regards to this. So I just want to make sure I'm understanding kind of the gist of the summary. It's very broad, as was just mentioned earlier, kind of on purpose. And the sense that I'm getting from this bill is that, please correct me if I'm wrong, is that the intent of this is really to trying to treat gun violence as a public health epidemic. Is really trying to get at this from a lot of different angles, not simply be reactive, but an attempt to be proactive to try to prevent future gun violence. Am I correct with regards to this?
Yes, I wish you were on this side of the table.
I'm familiar with a number of different groups. There's a Community Action Justice Fund, which was founded by actually really one of my really good friends, Amber Goodwin, who I've known for like 20 years. I know they do a lot of this type of work in trying to treat gun violence as a public health epidemic, something that she's been working on for probably the last 15 to 20 years on a national level. And so when you're talking about this piece of legislation, it really reminded me of that. And so I guess my question is that the reason for the broadness is to really provide that flexibility, I guess. Is that what you're getting at? The flexibility to try to treat this to be proactive in dealing with this issue as it's to cater to the communities throughout the state, and to cater to what the root causes of, because the root causes of why gun violence occurs can vary from community to community, from jurisdiction to jurisdiction, and that we need to make sure that we're addressing this from a holistic perspective. Is that what I'm hearing you say, Madam Secretary?
Absolutely, absolutely. If we're too prescriptive in the language of what we're trying to accomplish, it may rule out or eliminate certain jurisdictions, and we wanted to keep the bill as open as possible, again, to the governor's core mission of safer communities. Safer communities means all safer communities. And the only way we're going to start understanding what that means is by going upstream and taking a little bit of a different approach, and not just relying on the data we have today about the violence that is happening, but are there markers before the violence happens, and could we go intervene before then? And how do we use data? And how do we use centers like at Hopkins and the research that's happening? And how do we use community partners, or even King's own experience? And what are the lessons learned? And were there any markers in this particular situation that we could learn from to prevent something like this from happening again? So it's all of the above.
Thank you so taking this approach, it would also open us up as a state to federal funding that we can get from the federal government. I believe the current federal administration is really also establishing a similar programming that would allow us as a state to apply for those federal funds to be able to do some of this work. Is that correct?
That is correct, as well as the CDC is doing some of this work, and certainly Department of Justice. The goal would be, as we learned about what is happening in the opportunities in the state, that we could apply for and receive other federal dollars that we could bring to the state of the Maryland to help solve this problem.
Okay, thank you so much. That's all I have.
Thank you, Mr. Chair. Part of the problem I have with this issue is that we never really do anything substantive with this problem. It's been advised to us that the Center for Firearm Violence Prevention would be the first of its kind in the country. That's not actually true. We have what's called the Maryland Gun Center, Public Safety 5804B. It's ironically called the Center. The center shall assist with the department and law enforcement agencies with firearm enforcement and firearm violation reduction efforts. So we actually already have a state agency that does this. They coordinate with law enforcement to vet all firearms crimes, determine individual charges for crimes. They recommend specific charges. They work with protective orders. They assist law enforcement investigations. They do background checks. And we know from cases in this state, for example, the Duncan Lemp case, where allegedly he possessed a firearm that's on a prohibited list, they didn't do a background check and he got shot to death in a no-knock warrant. So I get the intent, but we have clear cases where we know that law enforcement agencies should be coordinating here. We see that they're clearly not. And you're suggesting a $10 million new bureaucracy for something we already have. So my question is, why wouldn't it be more prudent to work through the Maryland Gun Center, which is supposed to be doing this already per our public safety law?
I can start and then you. It's a very different model than what you described. That's still very much a policing model, and that's not what we're trying to do.
Yeah, and I just to elaborate on that, the Maryland Gun Center is a wonderful law enforcement tool. Okay, but it is law enforcement, and law enforcement comes in on that back piece of we've already either seen the gun violence or we've seen something, and we're trying to get, that taken care of from the end point. This is before, well, generally before that, but also just an overall landscape. So law enforcement, the Maryland Gun Center would be a piece of this. It would be a collaborator. It would be, a way of pulling that part of it together, but it is very different. As the secretary has said, the overall model is just, that's a law enforcement tool, and that's not really what we're talking about in this moment.
Yeah, I agree with that. As far as providing trauma, that's something totally different. For like King, he has siblings. So where can my other children go to get that help, that emotional support, that, that just that support overall with the grief. So I think it's totally different as what you stated to what we're trying to, or what they're trying to propose. And it's much needed with what we're going through, because it's tackling the main cause of the crime that's going on and the kids that's committing the crime. That makes sense.
Thank you, Mr. Chair. Thank you guys for being here. My question's for the secretary. I noticed that DJS is missing from this bill. Would you guys be amenable to putting in black and white that they're going to be included? Because I feel like they've really been missing from the conversations around how can we tackle this problem. And at the end of the day, they have an enormous amount of control over what actually happens. And especially in terms of the kind of services that they're offering, what types of therapies are available. I mean, happy kids aren't killing each other, right? So how can we figure out what's really going on and then match them with a type of therapy that's actually effective? Because a lot of this talk and psychotherapy at the end of the day isn't actually leading to improved outcomes for kids that are suffering from real trauma. And these kids have real trauma. And it just sometimes feels like we just talk around the subject. So what I'd love to see if we could accomplish, now this is obviously a giant fiscal note, and the chances of I think it staying in this form is probably it's going to get tweaked, but ideally down the road, once we've all gotten on the same page, how can we find out what actually works? And is that really the goal of this, to figure out, okay, here's what these kids are actually dealing with. Here's how much they're suffering. And here is a solution that actually is showed, peer reviewed, it works, it's helpful. Because, you know, a lot of the stuff, it's just very political. And at the end of the day, the mental health piece is really getting lost because it's so politicized. And that's heartbreaking, because I feel we could have probably addressed this 20 years ago, because I bet the research is there, but we're not bringing it to the table because we just want to pass bills and say, oh, look at the bill I passed, it's got my name on it. Children are dying while we're trying to politicize this. So if you could bring DJS in, you know, we need them at the table for this.
So I will tell you that I'm already connected with DJS and I'm connected with DHS, and quite frankly, I'm now connected with MSDE with Acting Superintendent Wright as its current leader. And we are all already doing that work to coordinate resources and to identify gaps in the system that we need to better serve our kids. And so this is what you described. It's really understanding what's been published about what works and working with researchers that maybe have done small pilots and taking the things that work in a small number and taking them to scale. But it's not enough to just take a program and lift it and say you do it. Every tweak away from an evidence-based model, you lose that evidence. So it's also ensuring the fidelity to the model. So if this is the way it worked that brought success, how do we replicate that exactly as the way the research is intended it to be, to ensure that it has the same outcomes? That's just one example. Totally agree on the behavioral health work. We're doing a lot of work in that space already. We're working on a behavioral health strategy for children and adolescents, and how do we bring our services to bear? I mentioned DHS and DJS already and MSDE, but it's also working with the consortium on the blueprint dollars, and how do we work in partnership with the services that are being provided in school to stabilize kids in school. So it's multiple things that we're working on, but it's everything that you described, and then deploying what we know, or at least what has been tried and worked, and taking those interventions to scale.
My other question is, you know, some of these kids who experience trauma probably shouldn't stay in the environment that they're in the school that they're in. And so I think, and it would be nice if you could take back to the administration, some of these kids should get a voucher to leave the area that they're in because it's hurt them so badly. Those children will not recover if they stay in the environment that destroyed them. So, I mean, I would just offer that as a suggestion to take home and see if the powers that be might consider some type of voucher for trauma, because children are not recovering in the place that hurt them the most. Thanks.
All right, seeing no further questions, thank you very much. We're going to go to the next panel. Taria Stanley, Adam Rosenberg, Heather Warnken, Tony Gedden.
I'll start while we're getting ready here. Good afternoon. I'm Adam Rosenberg. I'm the Vice President for Violence Intervention and Prevention at LifeBridge Health and the Executive Director for the Center for Hope, our comprehensive response to all forms of violence in the greater Baltimore and Carroll County region, from child abuse, domestic violence, and community gun violence there. I'm testifying in strong support today of House Bill 583 for the creation of the Center for Firearm Violence Prevention. You're certainly familiar with our work in many years of child abuse prevention field. I've had the privilege of coming before this committee and working with many of you for many years to help children who've been impacted by child abuse. And we, over these course of many years, saw the same need to respond to children who'd been impacted by gun violence there. The long-term adverse health effects of being a victim of child abuse and neglect are very similar to having been a victim or a survivor of homicide. This is among our top health concerns for LifeBridge Health in the area of gun violence And as one of your delegates had stated, this is a public health crisis that we need to respond to and keep people out of our emergency rooms and keep them healthy there. And that's why we're in strong support today for the creation of a Center for Firearm Violence Prevention. This public health epidemic is that guns are now the #1 killer of kids across the United States in all communities, rural, urban, suburban. It's the #1 method of suicide as well. And so this is a public health epidemic that, as we've responded to other crises, we need to provide new moonshot solutions to be able to provide answers for this there. This body has passed a great number of important laws of gun safety over the years. In fact, the Giffords Law Center ranks us as the 8th of 50 states in gun laws. However, our gun deaths still exceed the national average. And so we need to find ways to do better. And the creation of this will be able to help coordinate, create, and find new solutions, such as public health campaigns, partnerships, and the effective use and enforcement of existing laws there. In conclusion, great community challenges require solutions and actions. Community thoughts and prayers simply isn't enough. And the creation of a center like this, which we look forward to working with and seeing evolve, will greatly help reduce gun violence in Maryland. Thank you.
Good afternoon, members of the committee. My name is Heather Warnken. I serve as Executive Director at the Center for Criminal Justice Reform at the University of Baltimore School of Law. Our center is a proud part of the Maryland Violence Prevention Coalition and co-signed the coalition's written testimony and white paper laying out the extensive research behind the need for HB 583. So prior to my current role, I served at the U.S. Department of Justice in the first ever position dedicated to bridging the gap between research, policy, and practice to improve our response to crime victims. In this role, I led an assessment for the City of Baltimore on its victim services, focused on the response to victims of gun violence. The tragic findings in our report were again laid bare when I participated this summer in the response to victims of the devastating mass shooting at Brooklyn Homes. We have so far to go in building a more effective trauma-informed approach to not just supporting and healing those impacted by gun violence, but in interrupting the cycles of harm that perpetuate it. An over-reliance on punitive approaches has fueled the reality that too often Black residents impacted by gun violence in particular, especially those who are poor or who have ever touched the system previously, are more likely to be criminalized than seen as human beings deserving of dignity and support. The mayor's office has brought together a multidisciplinary group of stakeholders working to implement the 21 recommendations in our report. The statewide collaboration and coordination made possible by HB 583, the Center for Firearm Violence Prevention, will bring this work of deploying our resources more effectively to the next level. We urge a favorable report. Thank you.
Good afternoon. My name is Tony Gedden, and I'm the health officer for Anne Arundel County. And I'm here today representing the Anne Arundel County Health Department, as well as the Maryland Association of County Health Officers, in support of House Bill 583. This center, I think, means a lot for local health departments and our work in this area. In Anne Arundel County, we've been able to prioritize gun violence as a public health issue. And so what that means for us is that the health department leads a multidisciplinary agency group, the Gun Violence Intervention Team, to really look at what are the causes of gun violence in the county, what can we do to address it. And what we know is that from a health department perspective, our goal is to promote, protect, and preserve the health of the residents. And so looking at how gun violence is transmitted, similar to that of other disease states, you can look at data and really understand where the areas of gun violence are happening, understanding who may be a victim of gun violence in order to have upstream solutions to really address what's happening. And so having this center at a state level is very helpful in sharing best practices, additional research, technical assistance for local health departments, and funding, being able to utilize and understand what's happening at a federal level that's coming through the state to help us at a local level better utilize resources and to be availed of those resources. I think I'm often asked, Well, I'm surprised you all are working in gun violence. It shouldn't be a surprise. It is a health issue. The ongoing health ramifications of gun violence for folks who have been victims, their families, the communities, both mental and physical, are ongoing. And so it is our role to really decide what we can do and to put forth evidence-based solutions and look at the evidence to understand how we can better protect, promote, and preserve the health of those that we.
Good afternoon, everyone. My name is Taria Stanley, and I am the Regional Advocacy Manager with Community Justice. Hi, Delegate Williams. As Delegate Williams stated earlier, we are a national organization that focuses on preserving the lives of Black and Brown individuals, but particularly trying to protect Black and Brown communities from gun violence. I also sit as co-lead for the Marylanders to Prevent Gun Violence Coalition. And we are here today in support of the center, the proposed center, and that is because we are here because we cannot and must not hide from the harsh truth, and that is gun violence is ravaging communities around the country and here in Maryland. Everyday families experience firsthand the devastation gunfire brings. In Maryland alone, each year, an average of 796 people die, and another 1,363 people are wounded by guns. We cannot continue losing lives to gun violence when we have the solutions right in front of us. To ensure a public health approach, we want to center the communities closest to the pain and make sure they are at the forefront of these conversations. Establishing a Center for Firearm Violence Prevention addresses the gaps in the life-saving work that is already happening in Maryland. The creation of the center will advance Maryland's public health approach to violence reduction, driving investment in the interruption of cycles of violence to protect the lives of Maryland communities. Data shows community violence intervention improves the safety of our communities. According to the research done by Johns Hopkins, released in March 2023, Safe Streets, which is one of the community violence interrupter programs that is happening in Baltimore, was associated with a statistically significant 23% reduction in non-fatal shootings. And with this data, the proposed Center for Firearm Violence Prevention will serve as an intricate piece to facilitate federal, state, and local agencies and bring forth impactful solutions to gun violence in Maryland. This is why we are in favor of the proposed center bill.
Are there questions for this panel? Delegate Conaway.
Thank you, Mr. Chairman. Thank you, panel, for coming in to testify. So you're saying that gun violence is a health issue. This is for you all in general. Okay. Earlier, the people who were involved in these type of altercations were labeled as acting out, and they were acting out their conflict resolution. Do I have that kind of correct? Anybody?
I can't comment to what the conversation on the last panel was, certainly.
Okay, good. Do you think that children or juveniles that have watched a significant amount of cartoons when they were growing up, they got ideas about their behavior, which might be inappropriate from watching things like Bugs Bunny, Roadrunner, Wile E. Coyote with Acme explosives and things like that, and then adult movies like Django, where they all portray violence as a way to resolve your conflict? You think that has any kind of influence?
I think the influence that's on it is from children who are regularly living in communities that are experiencing a massive amount of gun violence. The kid who has to walk over a deceased body on the way to school, or the children who my colleague in health here and all of our community health officers convene a child fatality review where we're regularly discussing children who've been shot and killed. And unfortunately, the survivors of those homicides are the ones that are coming back because they haven't gotten the services and the responses that they need. They become victims later, and they become trigger pullers later. And so far more than an Acme cartoon necessarily, necessarily has been, unfortunately, we haven't necessarily addressed the impact of gun violence on children there. And that's what the center really aims to be able to do, is to be able to look at those long-term physical health effects, mental health effects, social health effects, to be able to prevent that from happening there. So then finally, when we can address this, then maybe we could also look at some of the other societal factors there about cartoons. But the real impact here, unfortunately, delegates, is the fact that these kids are living with violence on a regular basis in their urban community, in their suburban community, in their rural community. And the prevalence of a gun is so out there that the solution to go from conflict to gun is so quick, and we need to be able to find other ways to be able to dissuade that behavior there and help people resolve conflicts peacefully and be able to have safer gun laws and gun societies there.
That was a wonderful speech. Do you live in one of these areas you're talking about?
I live in Maryland, and Maryland right now,
Do you live
guns
in
is the number
Baltimore?
one.
Have you ever lived in a high-rise project?
I've
Ever
never lived
visited a high-rise project?
I've worked regularly, but I've never lived in a high-rise project or
So you don't know
delegate.
anything about Argyle projects in Baltimore City, anything like that?
I know a lot about projects and living in Baltimore City. I work regularly and proud to work alongside 6 Safe Street sites there through us, who regularly tell us the challenges and the struggles that they face there. We're doing the best we can do here, delegate, to be able to prevent gun violence there. And so we take that on, and we want to keep people who've been victims of gun violence out of the emergency room.
I'm not against your bill. I'm just against some of the statements that you make.
I'm not sure what statement I made that you're against there, but
I'm just against some of the statements. I just want you to know that, but I'm for your bill. So thank you.
Thank you.
Yes. Thank you, Mr. Chair. I just wanted to kind of circle back with Ms. Stanley, if that's okay. I know you ran out of time there. If you wanted to, I guess, kind of elaborate on maybe some of the work that you all have done here in Maryland, and really other parts of the country. I know you just finished up a training in Nevada. And if you wanted to kind of elaborate on the work that has been done with your organization and other organizations like you, and how effective it has been in curtailing gun violence in the various communities and where you guys have set up various community groups.
Yes, of course. So again, I'm with Community Justice. We are a Black and Brown survivor-led organization. We work with the federal, state, and local level when it comes to the work that we do. We also make sure that we center, again, Black and Brown communities in the work that we do. So although we do connect with policymakers, we make sure that our heart and soul in the work that we do is within the communities. So we connect with organizations like Safe Streets. We connect with organizations like ROCA and different organizations that are in New York and California and New Jersey and all of these different organizations across the country who are also doing the same work that is happening here in Maryland. And we talk to them about some of the resources that they need. So therefore, we see the resources that are needed here in Maryland, right? And this is where the center comes in. It comes in to offer those resources. And we've had these same conversations in the state of New York. We've had these same conversations in California. We've had these same conversations in North Carolina, where they have set up offices of violence prevention to take on, the issue of gun violence. And we know that Maryland can also be one of the few states to do the same and support the work on the ground that is already happening with some of our key partners that are also in the coalition as well.
And can you also kind of talk about the effectiveness that this has had in curtailing gun violence in the communities and where you all have partnered with?
Yes, of course. So I know that I gave the statistic for Safe Streets earlier, but we've also seen a curve in gun violence in New York. Sorry, I don't have the absolute statistic on the top of my head, but we do know that some of the organizations that are on the ground in Brooklyn, in Harlem, through the state of New York that are doing the work, and that's in work with the governor's office as well, with the work that's going on out there. They've seen a huge curve in violence out there, and same for California with some of our coalition partners out there. So this work is impactful. It does work. We do have the data to show that it works. This is evidence-based work that we're going off of. So it's highly impactful, and we make sure, again, to keep the community at the center, because the community is the one that we're wanting to support here.
If I may add a data point, Delegate, to your question, at LifeBridge Health, through our combination of community violence work and our hospital violence intervention teams there, we've seen a remarkable 28% decrease in gunshot wound admissions at our emergency rooms from fiscal year 22 to fiscal year 23. That results in an overall 33% decrease in the volume in the emergency room there. It is a percentage that outpaces the decrease in gunshot wounds all across Baltimore City. And then even more remarkably, since that fiscal year has ended, we are now seeing single-digit presentations of gunshot wound admissions in the health system there. It is a collaborative effort, and I think those are the sort of solutions that we hope that the Center for Gun Violence Prevention will be able to look at and see how we can replicate them all throughout the state of Maryland. Thanks.
Thank you, Mr. Chairman. Thank you, panel, for being here. I know this is of grave concern to you as well as all of us. My research has determined that approximately 65% of gun violence in the state of Maryland takes place in just 2 jurisdictions. I represent Carroll and Frederick counties. We have widespread gun ownership in households, and we have nowhere near the violence being perpetrated in those other 2 jurisdictions. My question is, would this potential panel look at our jurisdictions that are successful and get a better understanding of what works to help implement in those other jurisdictions that are being plagued with this violence? Thank you.
I think that that's a little difficult to answer because, as previously mentioned, the conditions in every jurisdiction are different, right? So I work here in Anne Arundel County. My colleagues for other health officers in other counties, we have very different makeups of residents. And so also thinking broadly about what gun violence means, oftentimes we do not think of suicide when we're talking about gun violence. And so that's a big part of what we look at here in Anne Arundel County. We have more suicides than we have homicides. And so thinking about how to address that and understanding what's actually happening from a data perspective in your jurisdiction, and then how are we looking to reduce that? So it may not be the same from one place to another. And I do think we can learn from one another what's happening from one jurisdiction to the next. But some of this is really having the resources and the funding to understand what's happening in your jurisdiction, and then what are the evidence-based solutions that you can implement there to hopefully successfully reduce gun violence.
Thank you.
Seeing no further questions for the panel, thank you all very much. We'll go now to those people who are in opposition.
Thank you.
We'll hear from them.
Thank you.
John Jocelyn, Kathy Wright, Taylor McKee. And you're ready to go.
Good afternoon, Mr. Chairman, members of this committee. My name is Taylor McKee. I'm with the National Rifle Association. We're opposed to the bill. The real solution to Maryland's crime issues lie not in creating more bureaucratic entities, but rather in strengthening policies and practices that target and punish criminal activities directly. For example, providing law enforcement officers with more and necessary resources and upholding Second Amendment rights for citizens across Maryland so that they can defend themselves and their families. This proposed office somewhat parallels President Joe Biden's White House Office of Gun Violence Prevention, and seems to be more of a symbolic gesture that's ineffective and driven by anti-gun donors. It's clear that such offices serve as political platform for posturing than as a solution to an actual criminal problem. The governor's approach only empowers criminals to act at the expense of law-abiding Marylanders. So instead of funding and increasing law enforcement's ability to lock up violent criminals and keep them off the street, it seems Maryland wants to spend $10 million on taxpayer money to fund another bureaucratic entity. That's all I have to say, Mr. Chairman. Thank you, sir.
Good afternoon, Mr. Chairman, members of the committee. John Jocelyn speaking for 2A Maryland. I've been doing this since 1988, and I've seen many, many bills like this that want to create a study or a bureaucracy or any other thing. What we end up with are a lot of reports that go nowhere. We recently had 2 bills that created an extended studies by the AG on firearms. I'd be willing to bet that not many of you in this committee have ever even seen, much less read those reports. This is what I call a treadmill bill. You see a lot of activity, but you don't see any forward progress. What you have is analysis paralysis. It focuses on firearm violence. Firearms are not violent. They are simply inert objects. What we're looking at is a people problem. It isn't hard to identify. Go back to the beginning, find out where the train went off the rails. And it went off the rails because we no longer have the nuclear families that we once enjoyed. And I'm talking about a father and a mother living in the same house with all the children and passing on to them the family values that most of us grew up with. When you don't have those family values, you end up with children who grow up with no socialization. They become armed. They don't know how to deal with anything. And at the first provocation, violence is their reaction. In essence, they have the social skills of a 3-year-old. We can fix this. We can go back to strengthening the families. We can go back to strengthening the education systems. And there's so much I could tell you about that. Things that we ought to think about are in the family: respect, social skills, honesty, love, loyalty, integrity, character, personal responsibility, the value of hard work, and yes, even religion. Those things seem to be now passé in our families. And until we fix the family, we are not going to solve this problem. Rome crumbled when the family disintegrated. We need to learn from the lessons of history. You also need to learn from the Roman philosopher Seneca, who said, sword kills no one, tool in the killer's hand. Focus on the people, the social, and not the object. Thank you.
Thank you, Mr. Chair. Thank you guys for both for being here. I know you guys have seen the fiscal note. It looks like it starts at 10 million and it goes up from there to it looks like 25 million by 2029. I'm just wondering if you guys have any of the data. I know you're new, so you might not. The other thing that Delegate Grammer had mentioned, state police runs something. I'd love to know if anybody knows what the cost is of that. And if we implement this, why do we have to have that running simultaneously? And then the AG thing you mentioned, what was that? Can you refresh
It was
that?
a firearms study to determine where firearms are coming from. It was passed in 2020, and I believe we passed an extension to it in 2022 because of the COVID problem. They now have 3 reports out right now.
I'd love to see that. Maybe I can get that from DLS.
I will forward those to every member of the committee.
That'd be great. And if you have any fiscal information on the cost of those things, because again, like you had mentioned, this is like becoming an expensive problem and we're not coming up with actual solutions.
And that's an interesting point because page 4, line 4, actually lines 3 through 5 indicates that if this bill passes, that there's to be a $10 million allocation in the 2025 budget. However, after that, the language says the governor may include in the annual budget. So we only have 1 year of funding and everything else is basically an assumption that it will continue. And this is reinforced in the fiscal summary, which says future years assume ongoing discretionary funding of $10 million annually. So this is not a done deal by a long thing. We could end up with the flash in the pan that everybody feels good because we passed this big bureaucracy and then it runs aground and sinks.
Yes, this question is for Mr. Jocelyn. My question is, you spent a lot of time talking about the decay of families and seeming to harken back to the concept of, leave it to Beaver and kind of things like that. But isn't it not possible that this center, and lamenting the decay of families as you see it, but is it not possible that this center could provide a wide array of resources and supports to families that aren't already existing? And secondly, and I'm sorry for this, I've tried to figure out how to say this nicely, but can you at least, even if you disagree with it, perceive how some people may view your pessimistic expectations for the center as somewhat cynical because it hasn't even been enacted. So so those are my 2 questions. Couldn't this provide more resources for the family? And isn't it slightly cynical to pan the center when it hasn't even passed the legislature yet?
Delegate, I would respond that it is not cynical, it's pragmatic honesty based upon 36 years of experience coming down here to Annapolis.
Thank you, Mr. Chair. Two questions. First, for the gentleman from the NRA. Have you seen similar issues to this passed across the country, and have they been effective? Not necessarily this bill, but studies, agencies, bureaucracies.
Most of them are in their preliminary stage. The White House just did theirs last year. You're seeing some pop up in other states across the Mid-Atlantic, but not too many of them have taken shape yet. And there's not enough data to support it either way.
Question for Mr. Jocelyn. So the threat to me seems not to be the strong men, but the weak men. Those are the dangerous ones to me. Can you talk, do you have any data about maybe fatherless homes? Because we continue to hear about this, children raised without a father, going on to be engaged.
I'm sorry, on the bill, please. I've let it go far enough. On the bill, if you have something to ask him with regard to the center, that's fine, but we're going to stay on the bill.
I'll retract the question. Thank you.
Thank you all very much. That appears to be all the questions here. That concludes the testimony on House Bill 583. Thank you very much. Go now to Delegate Cardin's bill, House Bill 498. And that's going to be Delegate Cardin, Grayson Wiggins. Michelle Siri, are you still here? Okay. Michelle Siri is here on informational testimony, but we're going to put her up there because why not? But we're going to let Delegate Cardin and get Mr. Wiggins, and they can come up. So she'll go third. She'll go third, to be clear. And I'm normally wouldn't put the informational person up there, but I'm just trying to move it along. Delegate Cardin.
Thank you. For the record, John Cardin on behalf of House Bill 498, asking for a favorable report. And this bill will just ask for the information that we are already collecting to continue to be collected on the matters dealing with the rent and non-payment of rent that we put through in the, what was the bill, the original bill?
The access to counsel.
The access to counsel and evictions legislation from 2 years ago.
Good afternoon, Mr. Chair, members of the committee. Grayson Wiggins here on behalf of Maryland Multi-Housing Association. We are in support of the bill. Thank Delegate Cardin for bringing it. As he noted, it's just moving reporting language from what has been in the JCR to statute. Thank you.
Good afternoon, Mr. Chair, members of the committee. Michelle Siri here on behalf of Maryland Legal Services Corporation. Here simply to answer any questions that you all may have regarding the various ways that happens routinely in my household. Happy to answer any questions about the reports that MLSC already submits on behalf of ACE to the governor, to the joint chairs of B&T and appropriations, as well as other reports from the task force on access to counsel and evictions. I would say I believe that there is an amendment, and I'm very grateful to Delegate Cardin for submitting that. That would sunset this to match our funding. I would suggest respectfully that perhaps it might be easier simply to remove the sunset from our funding and then leave this bill just as is. I think that would be very easy for everybody, but happy to have that amendment.
I did provide an amendment to the committee and to the staff that would sunset this in, I think, 2027 when the funding does sunset, and perhaps by then we can figure out a way to maybe keep the funding going, who knows. But I will note that members from both sides of this issue are here at the table today, all agreeing that we should continue to have this information as long as the funding is being provided. And again, the smarter, more effective communicator, who I also went to law school, is sitting next to me once again. So twice in one day, Mr. Chair.
That concludes the testimony on House Bill 498. Now we'll do Delegate Munoz and House Bill 659. We make sure Mr. Mohammed, Mr. Jocelyn's here, and then Mr. Penak's here. Come on up. Michael Shire, come on up. My understanding, this is basically the same bill that you brought before. It's just specific to firearms as opposed to, or it's specific to handguns as opposed to firearms.
Yes, sir.
Okay, go ahead.
Thank you, Mr. Chair. Good afternoon, Judiciary Committee colleagues. For the record, my name is Delegate Rachel Munoz, and I come before you today to humbly present House Bill 659, Theft of a Handgun. According to recent statistics from the Maryland State Police, handguns are the most commonly used firearms in violent crimes across our state. In fact, data shows that nearly 60% of all firearm-related homicides in Maryland involve handguns. These alarming figures underscore the urgent need for targeted measures to address the theft of handguns. Like the chairman mentioned, this bill, House Bill 659, is similar in spirit to House Bill 304, but with a more tailored focus on handguns. Elevating the theft of handguns to a felony offense underscores the gravity of this crime. Handguns are not ordinary items that simply disappear when they are stolen. Instead, they often end up being used far too often to perpetrate violent crimes, including homicides, armed robberies, and assaults. By categorizing the theft of handguns as a felony, we send a clear message that such actions pose a significant threat to public safety and will be met with serious consequences. Distinguishing theft of handguns as a felony offense empowers law enforcement agencies to more effectively combat gun-related crimes. Felony charges provide prosecutors with greater leverage to investigate and prosecute offenders, leading to higher conviction rates and a stronger deterrent effect. This not only promotes accountability, but also enhances public safety by removing dangerous individuals from our streets. Finally, changing the penalties from a misdemeanor to a felony for theft of handguns aligns with the principles of justice and fairness. It ensures that perpetrators of serious crimes face appropriate consequences for their actions, while also providing a measure of closure and justice to victims and their families. Overall, House Bill 659 represents a crucial step forward in our efforts to address gun-related crimes in Maryland. By differentiating theft of a handgun as a felony offense, we can strengthen our legal framework, enhance public safety, and create a safer environment for all Marylanders. Illegal guns in the hands of criminals take away our sons and daughters, mothers and fathers, grandparents and neighbors. For the foregoing reasons, I respectfully request a favorable report on House Bill 659.
Good evening. I'll start just say my choice of outfit today is total serendipity. And if you thought otherwise, then nice to meet you. My name is Mike Shire. I've been a police officer for 20 years. I chose a profession where they tell me what to wear every day. So I am here representing the Maryland Fraternal Order of Police in support of House Bill 659. We've testified in favor of these bills before. We believe that in order to combat the tide of violent crime in our state, we need to pull on multiple levers. You've heard bills recently, and we have measures in place to affect the levers of rehabilitation, social programs aimed at prevention. These are absolutely important. They are things that we should be doing, but we also have to take steps to deter crime, incapacitate and hold accountable those who are feeding the black market of firearms that are enabling the violence in our state. As was mentioned by one of the witnesses on the prior piece of legislation, we must take steps to prevent firearms from falling into the wrong hands. Well, every firearm that is stolen, every handgun that is stolen is automatically in the wrong hands. It is going into the black market. It is only being stolen because it is going to be used in a crime later on. This bill aims to pull on those accountability and deterrence levers. The other witness called it these things, pieces of the puzzle. They all fit together, and therefore the FOP supports this legislation and urges you to vote favorably on it. Thank you.
Thank you, Mr. Chair. Mark Pennick, President of Maryland Show Issue. We appear in support of this legislation. I would like to take the 2 minutes I have to address this issue where we left off last time on the last bill. 5-138 of the criminal law article already makes this possession of a stolen firearm a 5-year misdemeanor. And yet the theft of the firearm is a slap on the wrist. First offense, if it's prosecuted at all, probation under sentencing guidelines. Second offense, probation. If it's prosecuted at all, because the incentives to prosecute are simply absent. The incentives to arrest and go through all the paperwork necessary, absent. What the bill does is allow resources to be allocated to this end of the pipeline. And the pipeline is stolen weapons. And there's no doubt that stolen weapons are a huge problem. We wish to create a deterrence to the act of theft. Current law has no deterrence whatsoever. It's ludicrous for the thief not to even be disqualified for the act of stealing a firearm. Under Maryland law and federal law, if you are convicted of a crime punishable by more than 2 years, and it's a misdemeanor, it's disqualifying. Current law doesn't even attach a disqualifier. That's crazy, especially when 5-138 already attaches a disqualifying offense to it. We ask that the committee address this end of the pipeline and pass this bill. Thank you. It's a long day.
Good afternoon, Mr. Chairman. John Jocelyn speaking for 2A Maryland. Several sessions ago, the celebrated cause was we got to do something about ghost guns. That was the scourge that plagued the nation. So we made it illegal to possess a homemade non-functioning firearm. When I say non-functioning, I'm saying legally a firearm, but not yet complete with all its component parts. To sell or transfer the same non-functioning firearm carries a 5-year penalty rather than 2 years for just having it. However, if you circumvent all of the 28 gun bills you've passed since 1988 and acquire a firearm, a fully functioning firearm, by stealing it, it's only a misdemeanor property crime. There is a dichotomy here in where our priorities are. The law is currently in place actually encourages the theft of a firearm over building your own. If we're really serious and we want to look at firearm theft as the problem that it truly is, then we need to now start treating the theft of a firearm as the serious crime that it is. Because as the officer said, once it's stolen, it's in the criminal world. It's never going to be used legally again. So we need to treat that as a serious crime. And at the present time, we don't do that. We strongly urge a favorable vote on this bill. Thank you so much.
For the gentleman from the FOP, can you talk to us about the numbers of stolen guns in crimes, compared to, let's say, for example, a gun purchased illegally?
In our experience, when you're finding guns that are being used on the street for robberies and things like that, it's most often a gun that was somehow obtained illegally.
Help us understand what most often is. Give us a percentage generally. It's clearly going to be different jurisdiction to jurisdiction.
Yeah, it's going to vary. I don't have a specific number to give you, but in my personal experience, when I've encountered guns being used in crimes, it's almost always been a stolen gun.
Okay, thank you.
Thank you, Mr. Chair. And thank you, Delegate, for bringing this bill. Can you speak to the amendment? I believe there was an amendment to this bill as well.
Yes, thank you so much for the question. So I was really grateful on this bill to be able to work with the judiciary, and we changed, you'll see on page 5, it's originally said a sentence imposed under paragraph 1 of this subsection shall be separate from and consecutive to a sentence for any other offense. And working with the judiciary, we changed that shall to may. And so we're giving them that flexibility, and we're not making it as strict of a penalty necessarily.
Thank you, Mr. Chair. Thank you for coming in to testify. I was wondering, is there a difference between theft of a firearm versus unauthorized use?
Absolutely. So, for example, a minor that acquires improperly a firearm from his parents without supervision is unauthorized use, but he didn't steal it.
I like how you worded that, but you know that's not what I'm asking you.
No, I really don't.
I'm asking you if your son, well, your daughter goes in and steals your gun and takes it to school and for show and tell. Does that count as a theft or does that count as an unauthorized use?
I believe the definition of theft is by acquiring possession with no intent of returning it.
Yes, and I don't think that probably qualifies.
You say that again? I couldn't hear you.
I think.
No, I couldn't hear what you said. What?
My understanding of definition of a theft is when you illegally take possession of someone's property with no intent of returning it. For example, if you went joyriding in a car and then you intended to part it out at a chop shop, that would be theft because you weren't going to return it.
Right.
But
so
if you just went joyriding in it and left it at the side of the road, they would probably go to unauthorized theft.
So back on the guns. So if your daughter was to take your gun and say, I'm keeping this because you have several laying around at the house, a few in the barn, a couple hidden underneath rocks. Well, we do have a delegate that testifies to that all the time. And one of your children takes one of those weapons and keeps it. Would that be considered a theft or unauthorized use?
Probably unauthorized use. It depends on the facts.
But he just said if they take it and don't intend on returning.
It's delegate's a gray line.
Right.
So what can I say?
Thank you, Mr. Chairman. Delegate, why are you differentiating the theft of the crime of theft from the crime of possession?
Thank you. So we talked a lot about possession, and the gentleman here mentioned that earlier. So to be in possession of a legal firearm is one thing, and that's a problem. But I think the actual act of stealing it is something we have to address at this body, because I mentioned yesterday in a meeting that, there are children walking around the streets right now with illegal possession of firearms because they want to live through the night and wake up tomorrow morning. And so that's possession. But what we're talking about in this bill is people actually actively going into people's cars, into their homes, taking them off people and stealing firearms to then flood the black market with. And I think, dealing with possession is one thing. I think it's important, but I think theft is more important because that is the root of this problem, not the symptom.
My favorite question, Officer Shire, Lieutenant Shire, sorry, didn't mean to demote you. How do you steal something without possessing it?
You can't obviously, but the point is to give you
it's a distinction without a difference.
Right, the state's attorney's options in charging, certainly.
Delegate Valentine.
My questions were answered.
Okay, thank you. Delegate Boucher.
Thank you, Mr. Chairman. With the increase of the right to carry, are we seeing more theft of firearms from people leaving in their cars since they can't take them into more businesses, so to speak? Is that on an uptick?
So that's inevitable because this legislature has mandated in circumstances that you have to leave them in your cars if you're going to carry. So right now we have about 175,000 carry permits in this state. By comparison, Pennsylvania has over 1.5 million. Virginia's 700,000. So as those numbers increase, there's probably going to be more thefts from cars. So it's honestly, if I may have a moment of candor, it's idiotic to encourage people to leave their guns in a car. But that's what this General Assembly has done.
Seeing no further questions, thank you very much. That concludes the testimony on House Bill 659. Mr. Mohammed is on the line.
Yes, sir.
2 minutes.
Good afternoon. Good afternoon, Mr. Chairman, Vice Chair, Galen Muhammad, State Director, Maryland, for Maryland, for the National African American Gun Association. Definitely wanted to voice my my support for this particular bill. Currently, Maryland law states that the theft of any firearm less than $1,500 is a mere misdemeanor. Definitely wanted to point out the fact that it has to reach a threshold of $1,500 or more to reach a felony. That doesn't quite make any sense because a stolen firearm at $200 can create just as much mayhem as a $2,500 gun. The penalty for stealing any firearm should be a felony and should carry the same penalties. And for this, we ask that this committee receive come to a favorable review for this particular bill.
Seeing no further questions now, thank you for your testimony. That concludes the testimony on House Bill 659. We're going now to Delegate Roberson's first bill. $446. Come on up with your witnesses, please. And that's Heather Warnken, Natasha Kalfani, please. Delegate, go ahead for 3 minutes.
Thank you, Mr. Chair, Madam Vice Chair, Judiciary Committee, this being a week of first. This is also my first bill before this committee on this day. And I'm here urging your support for House Bill 446, which addresses the parameters around jury service disqualification. This bill has been introduced in previous years by Delegate Williams and prior to her, Delegate Fisher. And I'm hopeful that this year we will pass this bill. While serving on the Judiciary Committee, it has become evident that we must not only address how we engage with individuals when they're committing those crimes, but we also must address those who are incarcerated and also legislate to help those after they are integrated into society. This piece of legislation helps to do that. Although it was not yesterday, although they were not my panel of witnesses, we heard from individuals that were previously incarcerated and served their time and how they are willing to make a difference in their community to really grow us as a state. And serving on a jury is just one part of that process. I believe that it is important that we allow those individuals to serve, to take part. And one thing that stuck out to me yesterday was that one of the witnesses stated that they are the answer to our problems. But the sad part is they are behind those jail cells. But once they return into our society, they are also the answer to our jury service questions. The ACLU provided a testimony that you can read that says 71% of Black individuals are incarcerated in comparison to other populations. What that lets us know is that there is a lesser number of individuals who are of African-American descent to serve on our juries once they are released. And that also is a problem because as those individuals are sent into the judicial system, they also do not have a jury of their peers necessarily to serve on those cases. So I once again urge a favorable report from this committee. I'm happy to answer any questions, but we'll defer to the panel to really ask those hard questions. Thank you so much.
Good afternoon, again, members of the committee. Heather Warnken from the Center for Criminal Justice Reform at the University of Baltimore School of Law, here to express our strong support for House Bill 446. So access to a trial by a jury of one's peers is a fundamental tenet of the American legal system. Yet in Maryland, as we've just heard, especially for Black residents accused of crimes, it's simply not the reality. The statistics on jury exclusion are alarming. Across the country, approximately 1/3 of Black men have a past felony conviction. Thus, due to laws in numerous states, many Black jurors are excluded by law from ever even entering the pool. Maryland takes this even further, having both the highest overrepresentation of Black people incarcerated compared to our state's population, combined with one of the most restrictive jury exclusion statutes in the country. So Maryland is only one of a small handful of states which exclude people from jury service for both felonies and misdemeanors, which were punishable by incarceration of a year or more. So this bill would remove this outdated and highly problematic barrier, allowing for greater diversity of our jury pools and the reenfranchisement of people with past convictions who have paid their debt to society. Allowing for greater participation in this important civic duty is not only fair, it's more effective. It advances the efficiency and legitimacy of our system, demonstrated by research in our written testimony and a recent report by the Prison Policy Initiative. Enhancing the efficiency and legitimacy of our criminal justice system are both urgently needed. And for these reasons, we urge a favorable report. I would welcome any questions. Thank you.
Thank you. Good afternoon, Chair, Vice Chair, and members of the Judiciary Committee. My name is Natasha Calfany. I am the Acting Assistant Director of Government Relations for the Office of the Public Defender. I'm requesting a favorable report on HB 446. This bill will only allow for formerly incarcerated people to appear for jury duty and go through the voir dire process to be chosen for jury duty. It does not guarantee a person will be selected. I have had the opportunity to hear a number of formerly incarcerated people testify on bills before this committee as well as JPR. The insight, wisdom, knowledge, and belief in the legal and penal system that has been communicated makes clear that formerly incarcerated people are more than able to fairly and objectively serve on juries. Disqualification continues to perpetuate racial disparities of the legal system and social barriers experienced by those re-entering society. It often denies the accused the right to a jury of their peers. It preserves bias that occurs when juries do not include diversity of race, class, and life experience. It excludes the very group of people who are disproportionately and negatively impacted by the system. For these reasons, I ask for a favorable report on HB 446. Thank you.
I said Ben Kaufman too.
Oh, everybody else.
Thank you, Mr. Chair, and thank you so much, Delegate Roberson, for bringing forth this bill. You never forget your first, isn't that so?
It is so.
But more importantly, isn't the importance of this bill is to really also assist in making sure that our juries reflect the communities in which they live and in which the parties that are involved in the case that is before the court live. Isn't that so?
That's correct.
Okay, thank you.
Delegate Card. Thank you very much for bringing the bill. I love this bill. And I would love if we can get a small amendment on it. Maybe I can even get myself amended on as well. We'll see if we can do that, like change a period or something. Madam Professor, I guess I'll ask you. Can you just explain to folks who are not necessarily lawyers very quickly, what is voir dire?
The jury selection process.
Judge asks questions to the jury. What is the purpose of that?
To identify and populate a full jury of one's peers that can deliberate and participate in the process in a fair and effective manner.
Okay, and if the judge finds that somebody, because of a question he asks, like, is the fact that you're formerly incarcerated, would that impact your ability to make a fair decision based on the facts of this case? If the judge finds that somebody is not able to do that, what can the judge do?
Absolutely. So within the voir dire process, there's still the possibility of assessing on an individual person's basis based on their responses, whether they can participate in a fair and impartial manner. So for a particular individual, a factor or a past experience like that might impede their ability. But what this bill is about is making sure we don't exclude people writ large.
Is there any evidence that you know of across the country where there's some sort of data showing that ex-felons are somehow incapable of looking at the facts and dealing with the facts and making a decision based on the facts?
Absolutely not. And in fact, we cite in our written testimony data and research that speaks to the advantages of having a more diverse and representative jury pool.
And alternative perspectives. And last question, this would also, we right now preclude ex-felons from serving on civil juries, which has nothing to do with criminal matters. And this would allow them to at least at the bare minimum serve on juries that, or get the opportunity to try and serve on juries that have nothing to do with anything criminal that they may have been exposed to previously. Is that correct?
Yes.
Okay. Thank you, Mr. Chair. Why haven't we passed this bill yet?
For those who can't see what's going on at home, the entire committee, in celebration of Delegate Roberson's first bill, has decided they all have questions.
Only because we love him.
Only because they love him. And just to be sure, is there anyone who actually has a question on this bill? Delegate Kaufman, and then I believe Delegate Conaway.
Okay, so Delegate Roberson, and you can feel free to defer to your experts. But I wondered if you had a reaction to MSAA's opposition to your bill, particularly their concerns about somebody who's been convicted of bribery serving on a jury, because they can then they can allegedly use the fear is bribe the jury or extortion. And so I just wanted to see if you thought their concerns had any merit, and mostly give you a chance to respond because you didn't address it in your testimony.
Yeah, and actually I believe bribery is one of those that is listed out.
That's what I thought.
Yeah.
Gibson listed it as an example in his opposition, but generally, do you have thoughts on the MSAA? Okay, well, we are environmentalists after all, but do you have any general opposition? Do we have any general opposite? Do you have a reaction to the opposition of MSAA?
No, and actually we've spoken and are trying to work through is we've shared offline, to hear their concerns as well, to see where we can find an amenable way to actually get through so this bill can actually get passed.
Thank you. Congratulations, my friend.
Thank you, sir.
Thank you, Mr. Chairman. Thank you, Delegate and members of the panel for coming in to testify. So I was wondering if someone could someone explain to me what is one's peers?
One's peers.
So I'm happy to start on that. I think it's our aspiration that the jury pool be as representative of our communities, our diverse communities, as they can possibly be.
So you're saying people that have the common community, that's their peers at this point. That's what you're saying.
Well, I think
people who live together, that's your peers. Is that what you're saying?
Our fellow participants in society and lay people who are coming to participate in the process as a juror.
Have you gathered any data to find out how a person who's never been convicted of a felony would feel about being judged by a felon? Is that your peer? I mean, that's what I want. Is that your peer? If you've never been convicted of a felony, your peer who has been convicted of a felony has the ability to judge you?
I think there's so many different criteria that the person who's serving in the jury pool might have in common or different than the person who has been accused. So I think focusing in on the felony piece, one, it's completely overbroad given the huge range of different.
That's your opinion. That is definitely your opinion. Now, I don't know whether you've had a felony or not, but let's just assume that you have not had a felony. Do you want to do you think it's right for you to be judged by someone who has had a felony?
But I think, Delegate, that would also be opinionated as well. If you look at, for instance,
you have an opinion.
No, I'm saying legally, I can't say I want to be judged by a non-Christian if I'm a Christian, because then that becomes.
separating religion and state in here.
Do we though? But that's still
Yeah,
a
we do. I
criterion.
do.
It's a you do, but the judge might not. If we're gonna use that criterion, if this was banned out of here, just like we ban religion isn't considered, we also would ban the fact that you couldn't ask an individual if they had a felony or not.
If that's your answer on your first bill, then fine.
I'm sticking with it. That's my answer. That's my answer.
Anyone else really have a question for Delegate Robertson, Delegate Tolles? Delegate Tomlinson does. All right, Delegate Tomlinson.
Move this out of the way. Thank you, Mr. Chairman. I'm having flashbacks to a certain committee dinner that of an individual who educated me on jury duty for 3 hours, I think. The chairman knows what I'm talking about. But no, I do have a question. The individuals that if this bill passed, if this bill was to pass and we're able to now serve on a jury, and I really am asking this because I don't know the answer, because I know there's been a lot of law changes as regards to who is eligible to vote. And this body over, I don't know, sometime over the last decade has allowed more groups of people, former, incarcerated folks being able to vote. So the same folks that we're talking about here, that if this bill passed, would be able to serve on jury duty. Are they currently able to vote? Does anybody know?
They are.
They are?
Yes.
Okay. Gotcha. Thanks.
Delegate Tolles.
I have two questions. Since Delegate Carton put us in law school, how many serve on a jury?
You said how many serve on a jury?
Never mind, I'm trying to help.
12, is it 12 plus?
And the second
you have an
question
alternate,
is,
right?
yes, you didn't mention what district you represented when you. Could you tell us which district you represent?
District 25, Prince George's County's greatest.
Thank you so much. I wanted to confirm that. Thank you,
Thank you,
Mr.
Madam Delegate.
Mercifully, that concludes the hearing on House Bill 446.
Thank you, ladies.
Thank you. Good job.
Thank you.
Thank you very much. Thank you to the witnesses who stayed all the way to the end. That concludes the testimony for February the 14th. Just as a warning, tomorrow is likely to be a very long day. Please be aware that we're looking, I think, at 140 witnesses tomorrow. Please be advised, very long day. Thank you very much.